and we all know each other. I would ask each one of us to introduce ourselves. I'll just use my participants list, and possibly I'm an advocate, so I think I should start with the Honorable Judge so that we can also be alive to the protocol, as well as our colleagues from the National Steering Committee on implementation of the AJS policy. So maybe we could start with the judge and then Jedida, Madam Jedida.
Thank you very much, Annette. My name is Joseph Sergon, Judge of the High Court based in Nairobi Civil Division, presiding judge.
Thank you.
Good morning.
Morning.
My name is Jedida Warohio. I am a member of the National Steering Committee on the implementation of AJS, and I'm I sit there representing the Federation of Women Lawyers, and I'm also the chairperson of the subcommittee on public awareness training and sensitization. Thank you very much.
Thank you very much. Welcome to the meeting. I can see Amy is on board.
The chair.
Oh, this, yes.
We have Honorable Priska Nyota with us.
All right.
Yes.
Priska.
Good morning, everyone.
Morning.
My name is Priska Wamushi Nyota. I am a magistrate attached to Judiciary Training Institute, and I'm a member of Madam Jedida's committee. Thank you.
Thank you. Amy.
Good morning, everyone. My name is Amy Ogeso, and I work for Namatu Kenya.
I can see Larry. Larry, are you there? Okay, Lillian.
Okay, niambie.
My name is Lillian Jumba. I work for FIDA Kenya. I'm based in the Kisumu region. Glad to be here.
Thank you, Lillian. Then we could have Alice. Alice has introduced herself on the chat. Diana.
Good morning, everyone. My name is Diana Riga. I work at Kituo cha Sheria in the Advocacy, Governance and Community Partnerships program, and I'm happy to be here this morning.
Okay, thank you. And lastly, Janet.
Thank you, Daktari. My name is Janet Cavulovo. I work at Kituo cha Sheria as a program officer under the Advocacy, Governance and Community Partnerships program. I'm glad to be here, and welcome to all participants.
All right, I think everyone has introduced themselves. The rest would introduce themselves when they join in. So for me, just to give the opening remarks on my behalf, as well as on behalf of the Board of Directors Chair, that's Mr. Munithia, who has not been able to join us, but sends his greetings, and he's really in support of this conversation that we're having today. Just to thank you all for taking time to join us. And I think for us, this is a really crucial conversation to have at a very at a time when access to justice is becoming increasingly difficult, mainly for indigent communities. And we see that AJS actually presents a good opportunity to narrow the gap that exists for communities who are indigent to access justice. Reports show that around 10% of Kenyans approach courts, formal courts, and so we have majority of Kenyans actually preferring alternative justice systems. And so AJS is really a good opportunity to embrace this formally because most Kenyans actually use this platform for resolving of their disputes. We've seen our experience as Kituo is that during the pandemic, the use of technology by judiciary has in one sense enhanced accessibility mainly for practitioners, but then has kind of narrowed access to justice for indigent clients. And we as Kituo have come up with an innovation whereby we have set up a center where our clients and our community paralegals are able to access ICT services through our center. And that way they can then use the e-platforms that are being used by court, as well as use the e-filing system in an easy way. Sometimes some things are taken for granted, things like having an email account may not really be easy for, the rural person. And so just to ease accessibility to the e-platforms that are now existing within the space, the judiciary space, has really become important. And we are trying to do this through this innovation that we have started. And we are seeing that AJS then at this particular moment really is a good tool to use. And it's more accountable, it's more transparent, it's more accessible, and it's also more transformative. And we applaud the judiciary for adoption of the policy, as well as for the committee that is now embarking on implementation of this policy. And as Kituo, we wish to support the implementation committee in all its endeavors as it now seeks to implement the AJS policy. Just to say a brief remarks on what Kituo has done since we started working on AJS in 2017. And I think Martha and Janet will really share more on Kituo's model. But we have been working on AJS for quite some time now, around 4 years. And we piloted an AJS project in Kisumu, Trans Nzoia, and Uasin Gishu. And this project was mainly focusing on how AJS could be used to address post-election violence related violations. And we've seen a lot of successes, mainly in addressing some of the disputes that arose during the post-election violence in 2007, as well as later on in 2013 and in 2017. And we have now trained AJS adjudicators and commissioners in those 3 counties with the support of GIZ. We continue to build their capacity, strengthen them, and also identify cases, definitely in collaboration with the community members on the ground, cases that then can be addressed through using the AJS mechanism. And we saw that our AJS adjudicators and commissioners were particularly useful during this pandemic, when there was an increase in gender-based violence cases, and they assisted their communities in response to gender-based violence cases, but also just to enhance public awareness around gender-based violence. Finally, just to speak to our advocacy work around AJS, and I'm happy that Amy is here and she will also speak more to that. But we have, with again, the judiciary as co-chair of the Access to Justice Cluster Group, we are engaging with the Open Government Partnership Platform, which is a global platform of which Kenya is a member to that platform. And under this, in the towards the end of last year into this year, we were able to push for Kenya to adopt an access to justice commitment in its national action plan, actually the 4th national action plan. And so within this access to justice commitment, we identify implementation of the AJS policy as being a crucial aspect to enhancing access to justice. And what the Kenya government will seek to do then is to increase financing for implementation of the AJS policy, but at the same time use Mombasa County as a pilot project for cross-referencing of cases between the Mombasa judiciary and the Mombasa AJS structures that will then be established within the course of the year. So this is a 2-year national action plan. It was co-created with between the civil society actors and government actors, more specifically the judiciary and the National Legal Aid Service. And we right now have a cluster group that really is monitoring and seeking to implement some of the key milestones within that access to justice commitment. And I think Amy will speak more as to what has been done so far to kind of spearhead and support the steering committee as well in implementation of the AJS policy. So for me, I think just to lay the welcome you to this particular conversation, and I wish that we would have really a good sharing of what is going on, what is Kituo doing, what other players are doing, what the steering committee is doing, so that we kind of harness together efforts mainly meant to improve access to justice for communities in Kenya, and more so to see how AJS can really become realized on the ground. So thank you very much, and I wish you fruitful discussions, and I hand over back to Martha.
Thank you very much, Dr. Mbogo, for giving the opening remarks. I would like to proceed with the program and invite Justice Sergon to give the opening remarks on the part of the National Steering Committee on Implementation of AJS. Welcome, Justice Sergon.
Thank you. When I was introducing myself, I didn't mention that I'm a member of the National Steering Committee on Implementation. By way of introduction, I will be giving the journey that we've traveled as an AJS task force up to the stage in which we are now as a steering committee. So by a Gazette notice of 4th March 2016, the former Chief Justice, Dr. Willy Mutunga, gazetted or appointed members or a task force on the alternative justice to look into various traditional, informal, and other mechanisms used to access justice in Kenya. And when the task force started its work, of course, there was the politics of the name, which we managed to resolve and came up with alternative justice system to be our main title. The task force was required to inter alia examine the legal, policy, and institutional framework for the furtherance of the endeavors by the judiciary to exercise its constitutional mandate. It's directed under Article 159, Sub-Article 2, and its plan to develop a policy to mainstream AJS with a view to enhancing access to an expeditious delivery of justice as espoused under pillar number 1 of the Judiciary Transformation Framework, JTF, which later on came to be transformed as Sustaining the Judiciary Transformation Framework under the guidance of the retired Chief Justice Maraga. Under the leadership of Professor Joel Ngugi being the chair and Dr. Steve Ouma Akoth, vice chair, the AJS task force undertook its assignment diligently until the completion of the policy, which was transmitted to the retired Chief Justice Maraga on 17 August 2020. Justice Maraga officially or formally launched the AJS policy on the Katiba Day, 27th August 2020. One of the policy recommendations in the AJS policy is the formation of a national steering committee for the implementation of the AJS policy. On 9th December 2020, retired Chief Justice Maraga appointed members to the steering committee, mainly drawn from the AJS task force. And Justice Professor Joel Ngugi was appointed as the chair of that steering committee. It's important also to note that the composition of both the task force and the steering committee were drawn from the judiciary, LSK, the National Council of Elders, JTI, Kenya National Commission on Human Rights, the ODPP, AG, NCIC, Ministry of Interior, National Police Service, Chartered Institute of Arbitrators, Civil Society, ICJ, and the University of Nairobi. Some of the TORs of the National Steering Committee include just a few to mention. One was or is to develop operational guidelines for each of the AJS typologies defined by the AJS policy in Kenya. Two was to develop and keep detailed baseline and compendium of various AJS actors and systems in Kenya. Three is to assist various actors in implementing the AJS policy in meeting their obligations to protect, respect, and transform AJS. Four is to lead in demonstrating human rights engagement envisaged in the AJS policy as a way of transforming AJS in Kenya by capacitating the different actors on human rights framework and minimum constitutional requirements. Ayala mentioned about the mandate of the judiciary. It is clear from the background outlined herein above that the judiciary has given priority and recognition the need to promote AJS as directed under Article 159 2C of the Constitution of Kenya 2010. In the process of going around the country, the task force managed to identify and encourage pilot courts to promote and encourage the use of AJS. Some of those pilot courts, when you get time to visit, Kericho, Isiolo, Karatina, etc. And as a chair of the task force, the Professor Ngugi had a chance to make a determination applying AJS in matrimonial cause. Maybe it's important to note that number 24 of 2016, Lydia Wamboi Mwangi versus Paul Mundia, is the matrimonial dispute was referred to mediation under the court annex program. Mediation agreement was reached and mediation settlement agreement was filed in court and eventually adopted by the court. Parties had agreed to dispose of 2 plots in order to settle a bank loan and equally share the net balance. The defendant failed to share the net balance with the plaintiff, prompting the plaintiff to apply for the defendant to be committed for contempt. In the subsequent proceedings, the defendant claimed that the mediation agreement was obtained by coercion. Having heard both sides, the Honorable Judge held inter alia that a party who has reached a settlement agreement through mediation cannot unilaterally repudiate the agreement. 2, the judicial attitude towards mediation settlement agreement is informed by the citizens' commandment stipulated under Article 159, Subarticle 2 of the Constitution. 3, the defendant was ordered to comply with the settlement agreement. I'm giving this as an example. I'm giving this case in brief as an example of how AJS should be promoted and protected by the judiciary in compliance with the directive given under Article 159C, 159 Subarticle 2C of the Constitution. So even after now having concluded and came up with a policy document, the steering committee, those who are serving within the judiciary, have gone ahead and seized any opportunity to promote these systems. After all, the systems are working out there, despite the hindrance imposed on them, particularly like the repugnancy clause. And I need to take this opportunity also to appreciate the role of civil society in promoting AJS. They have played a very important role in training, in sensitizing, and funding some of these programs, like the way now Kituo cha Sheria is doing. And it's one of the most important role that will assist in promoting, protecting, and transforming AJS. And therefore, we as a judiciary, being part of the membership of the AJS steering committee, must appreciate at this stage. I think those are my few remarks that I wanted to make so that you know the background of the steering committee. Thank you very much.
Thank you very much, Justice Sergon. We are glad to find out the process that the AJS Task Force and now the Steering Committee and the steps they have taken in order to promote AJS and to advocate for its utilization in resolution of disputes. Thank you very much for those opening remarks. I am aware that there are several people who have joined us while Justice Sergon and Dr. Mbogo are giving their remarks. We would like to invite the new participants to introduce themselves, then we will proceed with the rest of the program. Karibuni. We could start with Valerie. Okay, it seems Valerie is unable to join at the moment. Ruben Kuto, kindly introduce yourself. Ruben? We can't hear you.
Hello?
Ruben, your microphone is a bit low.
Hello?
Hello, welcome. Now we can hear you. Thank you.
Okay. Sorry. I was saying my name is Ruben Kuto. I work with the Kituo Mombasa office, and I'm glad to be part of this conversation. Thank you.
Karibu sana, Ruben. I would like to invite Madam Julia, who is joining us from South Africa. Karibu, Madam Julia. Okay, it seems we have poor connection. Sally Miruri from Pamoja Trust.
Thank you, Martha. My name is Sally Miruri. I work with Pamoja Trust, and I'm glad to be part of this conversation. Thank you.
Karibu sana. With that, I probably will give the rest of the participants a chance to introduce themselves later. I'd like to proceed with the program. Next, we have a representative from the National Steering Committee on the implementation of AJS. Madam Jedida, kindly take over.
Yes, thank you very much. I believe you can hear me.
You can.
Yes, can you see the screen?
Yes.
Okay, thank you very much. I'm going to represent the steering committee, the National Steering Committee on the implementation of the AJS policy. And I'll pick up from where Justice Sergon spoke about in terms of the journey we have traveled. After the establishment or the operationalization of the National Steering Committee, the committee was tasked to operationalize and ensure the implementation of the policy and ensure that there is a good appreciation of what the policy was all about. I want to start with a quotation of the Chief Justice to show how the judiciary is very committed in terms of ensuring that access to justice is enhanced, is expanded, and is transformed. The Honorable Chief Justice Martha Koome, when she was being handed over the instruments of power on the 24th of April, she said that my team will build working relations with other actors in the administration of justice to reach our court users and other parties with a view of building their capacity with knowledge that will empower them to build their own agency and to become champions of justice. I believe this forum is one of those forums where we are consulting and are building an appreciation and understanding of AJS so that we can enable people to be able to enhance their use and access to justice by utilizing AJS and promote champions of justice. Justice Sergon has given the mandate of the committee, which I will not repeat, but it is very important for us to note that the mandate is very clear. Now, one of the mandates of the committee is ensuring that people understand what the AJS policy is all about. And I'll briefly just pick a number of issues on the AJS. I think one of the things that is important for us to appreciate is that, as Judge said, AJS is not new to any of us. We have been practicing AJS since time immemorial, even before the formal courts were established in Kenya. And also it's important to note that each of us in our own ways have a way of linking up with AJS, either at the individual level, at the family level, at the community level, in the offices, at the society level, and even at the national level. And it's important for us to know that AJS does not only capture the administration of justice from the point of dispute resolution. It goes further and ensures that there is peace, there is cohesion, and there is development. And that is the beauty about having AJS, alternative justice system, to ensure that we're able to promote all facets of life, not just dispute resolution. And you heard when Dr. Annette was speaking, she says that only 10% of the cases or the disputes that we have in the society go to court. Actually, it's even less than that. It tells me and tells us that more than 90% of the disputes that are in the community are managed by alternative justice systems, or people are forced to abandon their claims. Now, AJS is premised on Article 1. Article 1 is very important because this is where we constitute the power, where we say the people are sovereign. So whereas that some power is donated or delegated to the judiciary, to the legislature, and to the executive, AJS through Article 1 has a lot of residue, a lot of power that people still retain. And it is this power that is anchored in many of the alternative justice systems. And later on, you will see why that is important. So that there is AJS that can link with the judiciary, and there is AJS that remains with the people, and they're able to administer the same. So when we talk about AJS, we're talking about the practices that we have, the norms that we practice in terms of dispute resolution, the affiliations that we have that resolve dispute. You can think about like women in chamas or the border associations. There are dispute resolution mechanisms there. We also know that our traditions and our cultures also have traditional dispute resolution mechanisms. And this is what in the Constitution is called, known as the traditional dispute resolution mechanism. And that is why the task force spoke about informal and other forms of dispute resolution mechanisms. So it's both informal, others that maybe we may not even have an English name for them, and the traditional systems. When we look at AJS, we are talking about AJS from a philosophical perspective, a conceptual perspective, where we're expanding the whole notion and the whole administration of access to justice and the administration of justice. We are ensuring that our rights and freedoms are anchored in access to justice principles, where we are able to ensure that all of us, our rights, and especially our human dignity, is respected. So it is a whole conceptual framework of rethinking how we access and administer justice. Two, AJS also focuses on how access to justice is practiced. So it is practiced in many ways and comes in many shades and shapes. And these are the ones that are some of them, we have captured them within the AJS policy and cluster them to try and give a name and a meaning to those practices, so that we ensure that access to justice is not only effective and efficient, but also there is quality justice that is accessible and appreciated by all, and also anchored on Article 159. It is important for us to note that Article 159 is very important when it comes to the AJS policy, because it not only promotes the practice of AJS and also asks the judiciary to promote that principle of AJS, and that's why Judge was quoting the case of Lydia Mwangi. It is also says that AJS must be responsive to the human rights principle. It says that AJS must comply with the Constitution principles and not violate the same. And also it says that it must comply with the Bill of Rights, and also introduces a very old principle that we've had for long that will continue to challenge us as we continue, that it should not violate justice and morality. And that is an ongoing dialogue, and that is why within the AJS committees, we have 3 committees. One of the committees is on jurisprudence and drafting. That committee will help us break down what justice and morality means as far as AJS is concerned, so that again, we do not go back to where we came from during the colonial days, where anything and everything that is traditional and cultural is rendered to be unjust and rendered to be immoral. Now, the AJS policy takes on then a human rights-based approach, which is very important, which is a very important framework in justice and in the development. And what it does is begins to analyze what are the inequalities, what are the power plays within the AJS practice, so that the human rights are not violated. The aim of using a human rights-based approach is to ensure, one, that we are able to focus on those who are poor, those who are marginalized, and those who are vulnerable. Again, it ensures that we're able to focus on the sustainability of the AJS mechanism, because it's very important that we relearn and we rethink, but also we sustain the AJS practice in all its forms. It also begins to address and look at how do we increase the partnership and the participation of all as individuals and as institutions to ensure that the practice of AJS is across the regions. 4, it also begins to look at the service, the justice service that is being provided by the AJS systems, not as a charity or a philanthropic thing, but as a right to access justice. And finally, it begins to look at the capacities, not only of the claim holders, who are the right holders, but also of the duty bearers, usually in most respects, the state and other non-state agents, so that we're able to build the capacity of all. What the human rights-based approach can be summarized as is using the PANTHA principles. And PANTHA is an acronym of these principles, that when you're using a human rights-based approach in the alternative justice systems, it means that we must ensure the participation of all. We must ensure that there is accountability. We must ensure that there is non-discrimination. No one is discriminated. We also must ensure that there is transparency, both internal to the AJS and external to the AJS operations. We must ensure that human dignity of all is respected and protected by the AJS practitioners. We also must ensure that there is empowerment. And therefore, when it comes to capacity building, we're not only focusing on building the capacity of the AJS practitioners, we're also looking at the capacity of the AJS users. Just like the way you have court users, they're also AJS users, and building their capacity so that one is able to deliver the justice service and the other is able to claim and utilize that AJS platform. And finally, a human rights approach promotes that the rule of law, that is, the AJS must comply with the Constitution and also comply with the written law. And it is this approach that then within the AJS policy, you find that there's a human rights framework. And the human rights framework speaks to the duty. One, it has 3 focus areas. One, the duty to respect. It provides that no agency, no individual, no state or non-state will interfere with the practice of AJS. This is a very important duty to respect, because historically we know that a lot of our AJS practices, particularly those that were anchored within the traditional or cultural setup, were dismantled and rendered illegal and rendered bad by the common law system. So it is very important to know that if today you have an AJS practice and you apply it and approach the court will not interfere with your practice and say that it is illegal. No, it is part of the judicial authority to ensure that there is a practice of AJS. So there will be no interference. The only interference that there can be, it's an intervention on the AJS practitioner and questioning the issue of, have you complied with the Constitution? Have you complied with the Bill of Rights? Are you ensuring that the Panther principles are all in check in the AJS? That is the only reference point that any agency would interfere or would reference in any AJS practice. So the issue here is to ensure that there is mutual respect of the AJS practices. So an AJS practitioner, Kichuo calls them adjudicator, will be as respected as a court as a judicial officer. The second rights framework is the duty to protect. It is important that we continue to protect and promote human rights. So the AJS must protect human rights and fundamental freedoms all the time. We know that culturally or by way of certain practice, there are certain challenges that we have in terms of promoting certain rights. For example, the place of women, the place of children. So we must protect. One of the things that the AJS policy speaks to is that it says that when it comes to issues of sexual violence, that is an area that AJS for now should keep away from because of the power dynamics around that. But where AJS is practicing in other is undertaking an AJS determination on other parameters, that is fine so long as it protects and promotes human rights. And where there are human rights violation, either by the AJS practitioners or by members of that community, the AJS must provide remedies to the person, to the victim, and also hold the violators accountable. So the duty to protect is very important in terms of human rights. And lastly, the last human rights framework is the duty to transform. The AJS has a transformative mandate, and Dr. Annette spoke to this because it promotes the whole concept of ensuring a social change in the social justice parameters. And as I said, it is not only talking about, it's not only focused on the dispute resolution, it's looking about peace, it's looking on social cohesion, it is looking on development. So it has a whole transformative agenda. It expands the whole thinking in terms of the administration of justice and also how we access justice. It transforms the whole arena of access to justice. So those three human rights frameworks are very important when we are dealing with any alternative justice system. The committee, the National Steering Committee, is anchored at the Judicial Training Institute. That is where we are hosted. And we have the opportunity, we have the mandate to ensure that we are in close collaboration and connection with the Chief Registrar of the Judiciary and the Director of the Judicial Training Institute, and also get guidance from the Chief Justice and provide reports on the implementation of this policy. Now, what models has the AJS policy provided? It has, we looked and concluded that AJS policy will be promoted on 3 fronts. One is what we call the autonomous AJS model. By autonomous, and remember what I spoke about Article 1, these are usually the traditional dispute resolution mechanisms, which are really independent of everybody, any other party, including the judiciary. and they usually focus on using the principles of culture and customs. And each of us can think about our cultural communities and the kind of traditional mechanisms that we have. We have them, the most famous ones that are oftenly known as the Kaya elders of the coastal region, the Nchorincheke of the Meru, the other council of elders that are there. These are autonomous. They have no reference to any other institution other than themselves, their culture and their customs. And this model must and should be respected. The second one is what we call the third party model. And the third party model has a linkage with another institution. This could be CSOs, like we have the justice centers, we have the paralegal centers, which provide the dispute resolution. These are third party. We have the chamas, we have the religious frameworks within the various religions that have dispute mechanism. We also have state organs that have dispute resolution mechanism. This could be either the constitutional commissions or the independent offices, and also the many departments. For example, if you went to the children's department, there will be a place for a dispute resolution in respect to matters of children. This is what we call third party AJS model. The third one is called the court annex model. And the court annex model could be a hybrid of autonomous and third party, or classical autonomous and third party. It all depends on each institution, each area. The difference with the court annex is that this model is annexed to the court, and usually the court users committees plays a very instrumental role in terms of deciding that I think we need an AJS process where we can refer cases that are in court to the AJS, or the AJS can also bring certain matters to court for referencing. So this is what we call the court annex, similar to what we call them, similar to the mediation that is annexed to the court. So these are the three models that the policy promoted. We did look at our fourth model, which is called the regulated, where we develop a statute and regulate the AJS process. But given the history of this country and how we had the traditional courts and the role they played in this country, we thought that this was not the time to think about a statute-based AJS, because if we did that, we were going to erode the parameters, the originality, the uniqueness of autonomous or third-party models, which are already ongoing. So we said that we are not going to have AJS regulated for now, but again, this is one of the mandates that the steering committee has been given to see what sort of consensus arises along the way. So then, as I'm ending, the steering committee has 4 objectives. The first objective is to formally recognize and identify the nature of cases AJS can hear. Already we know that because of the variety of AJS models, there are very many, the AJS cases, AJS mechanisms listen to various cases from murder to SGBV to others. But it is very important we begin standardizing what can go before AJS, and ensure that we're able to capture the whole breadth of these cases. However, remember I said when it comes to sexual violence cases, the policy does not promote that for AJS. The second objective is to strengthen the process of selection, election, or appointment or removal of the AJS practitioners. I think it's very important because one of the things that we found is that a number of AJS, especially the autonomous, have very few include women, the youth, and persons with disability. So it's important for us to ensure that they are compliant with the Constitution, so that if someone has references their decision to court and raises a constitutional issue in terms of composition, that does not come to haunt them. The third objective is to develop procedures guidelines and the jurisprudence on AJS. The import here is that many institutions have been using certain guidelines and tools, and it's now for us to begin standardizing this and also begin having a jurisprudence, an indigenous jurisprudence. If you look at the judicial transformative, the sustaining the judiciary transformative framework, it talks about indigenous jurisprudence. What does indigenous jurisprudence mean? This is one space where we can start using significant case law developed and by the AJS mechanisms to begin documenting that, and also to begin learning what it is telling us in terms of the growth of the law in this country. Indeed, now the University of Nairobi has introduced AJS as one of the learning components. The other objective is objective 4, which is to facilitate the effective use of intermediary interventions. And I think this is very important when you think about paralegals and other human rights defenders who assist in the administration of justice. So how are we going to use and integrate the use of intermediary, which is a constitutional principle under Article 57 within the AJS? And I think this is very important so that we are able to support, especially those who are vulnerable, those who are marginalized to be able to access justice within the AJS mechanism. The third objective is really to strengthen and sustain resource mobilization, and including have a rational way of allocating the resources. We need to start asking the question, how do we allocate the state funding within AJS? And I was very happy when Dr. Annette, you spoke about the Open Government program, which is the 2-year program where you've been able to integrate in the 4th action plan the whole issue of access to justice in respect to AJS, and the whole issue of increasing financing. And this, I think, will be a very important place for us to start seeing how we allocate resources to AJS if 90% of the cases have been determined out of court, and what rationale we are using for the same. Finally, how do we get involved in this whole process? I think the first place is for us to read the AJS policy. I've just merely scratched the surface on the AJS and given the key highlights that from my point of view, I thought were very important. So it's important for us to understand the AJS policy and also to look at the there's a whole strategic plan that comes with the AJS policy for the next 5 years, because the committee has a mandate from this year 2021 to 2025. So it has a 5-year mandate. So it's important for you to understand the AJS policy principles and the models there and the operationalization, and then look at the priorities that have been identified. 2, it is to identify within those strategic priorities what areas you can work with, support, and work together with the committee, so that part of it will be non-financial, others will be financial, so that we are all pulling in the same direction. The other area is also around public education and awareness. I think it's very important for us to speak a lot about the AJS policy, speak positively about the various AJS practices, so that people know that it is okay to have an AJS practice even at the doorstep of the court, and there's nothing wrong with that, so that people begin appreciating that these services are available at the AJS, and the courts also begin to know that these are the various forms of the AJS practice within that county. The 4th thing is really to map, to support, to link, and to document these AJS practices, so that we can understand who are the AJS practitioners, what sort of cases are they administering, what sort of process, how are the processes, just like in court, what are the processes, and how do they determine the cases, and what sort of cases do they determine, and also begin documenting this. Because you see, there's no way we are going to grow our jurisprudence if we don't document what is happening. And this will help in terms of guiding the jurisprudence and also the practice tools for the AJS practitioners. Also, if you read the AJS policy, you realize that we didn't deal with everything. The whole concept of AJS is huge and wide. We just decided to focus on those things that were very, very essential to start off, because this is the first practice of AJS documentation by the judiciary. So we needed to start somewhere. So there's still so much, there's still a whole avalanche of knowledge, a whole body of knowledge that is not there. So I think it's important for actors who are committed and specializing in AJS to begin conceptualizing research areas that will deepen the practice of AJS, maybe on sexual and gender-based violence, maybe on issues of land dispute, maybe the issue of how do we protect special interest groups. These are whole imaginary areas. The whole concept of economic justice. How do we ensure that AJS mechanisms are sustained? How do we link them better with the judiciary? How do we transform the whole administration of justice network and parameters? I mean, I could speak about this for a long time. So let us think about those areas. Let's see how we can collaborate and work together to deepen this body of knowledge, both in terms of practice and theory. Remember, AJS is more practice than theory, but we are able to study the practice and emerge with the theory and the policy principles around that. The other thing is, how do we manage and develop the knowledge around AJS? I think it's very important to start documenting the best practices that we have in the AJS practice. It's very, very also important to begin writing and publishing this kind of dialogue. It doesn't matter what shape they are, but the fact that we start this process, we are beginning to manage that knowledge. We are beginning to develop jurisprudence. A lot of the writings have been more from the academia. The practitioners need to start putting their pen to paper so that we start documenting and managing this knowledge. And especially when you think about the autonomous AJS, because the autonomous AJS is very heavy on the older members of society. And remember, many of them will not be with us forever. How do we capture that knowledge, document it, so that those traditional dispute resolution practices, some remedies that are very innovative, are not lost and are captured, so that we're able to develop that body of knowledge. Finally, allow me again to end with the Honorable Chief Justice. And I think it's very important that we anchor AJS within the Chief Justice. This is the third Chief Justice since this process began, but this is the first Chief Justice who will guide us in terms of developing ensuring the implementation of the AJS. And this is what the Honorable Chief Justice said, that if there are cases to be heard, let us conclude them. If there are problems to be solved, let us resolve them. If there are barriers to overcome, let us overcome them. If there are changes to be made, let us make them. And I think that is what we need to ask ourselves about this whole AJS conversation, this whole AJS implementation. What things do what barriers do we need to overcome? What changes do we need to make to ensure that access to justice is done and also sent to be done? And she concludes by saying, I invite you all to join me, that's the Chief Justice, in this journey. And we also invite you all as the National Steering Committee on the implementation of AJS, so that together we can move the judiciary and our country to a better, more secure future. It is our hope and prayer that we'll be able to transform the landscape of access to justice and the administration of justice through the use of the AJS mechanism. Thank you very much.
Thank you very much, Madam Jedida. That was a very broad and well-written brief on AJS policy. We are glad to hear that some of the objectives that we have hit for the policy are some of the activities that we do, and I'm sure also other organizations are implementing in their various projects. So thank you so much for that presentation, and I believe there are people who will have some. Can you hear me? It's better now. I understand that I'm not very clear.
Yes, now we can hear you better.
Now you can, okay.
Yes,
Okay, thank you. Yes, so I was saying thank you very much, Madam Jedida, for the presentation on the AJS policy and for briefly explaining the conceptualization of the policy and how it will help the people of Kenya. We are glad to hear that some of the things that you're planning to do, some of the objectives are part of our activities in our AJS project. We will speak more about that later on. But before we speak about the Kituo AJS model, I would like to invite the participants who have just joined us, some of who are our partners in this AJS project that we are currently implementing in Eldoret, Uasin Gishu County and Trans Nzoia County. So I'd like to invite Mr. Matthias Smith to briefly say hi to the participants. Mr. Matthias is involved in another training, so he informed us that he would briefly say hi to everyone and before he proceeds with the training that he was attending. So welcome, Mr. Matthias.
Thank you very much and good morning to everybody. My name is Matthias. I'm a GIZ Peace Building Advisor. GIZ is the German Development Corporation, and we are especially focusing on supporting the alternative justice system here in Kenya. We're doing this together with different partners, well-known partners such Kitusha Sharia. And I'm very glad that I got some time, like has been said, I unfortunately have another training today, so I don't have that much time, but I really appreciate being here and to listen to you guys and also to really get further knowledge on the policy actually and how we can support implementing it. So thank you very much and really keep on going. Looks very nice. Thank you. Asante sana.
Thank you so much, Mr. Matthias. There are also other participants who joined us. Rafiki Kamweru from Pamoja Trust.
Hi, my name is Rafiki Kamweru. I'm an intern at Pamoja Trust. Yeah.
Welcome, welcome, Rafiki. Dorcas.
Apologies, Martha. Earlier on I was using my phone, but it's run out of charge, so I'm using the laptop, and it was registered.
Okay.
And this is mine.
Okay, thank you, thank you. Anyone else who's just joined us?
Thank you, Martha. Good morning, everyone, and apologies for joining late. I had some technical issues. My name is Steve Biko from AGCP Department, Kituo cha Sheria. It's a pleasure, even though I joined a little bit late, but gotten some insight from the presenter, Jedida, and thank you.
Thank you very much, Steve. Anyone else? Madam Phoebe. Madam Phoebe was one of the people we started this AJS project with in Western Kenya. I'm not sure, I can't see her microphone on, so I'm not sure if she's able to speak, but welcome, Madam Phoebe Akinyi. Yes. Okay, thank you very much. I believe everyone who
Martha, you're muted.
Yes, thank you. I am advised that there are some people who might have some questions based on the presentation by Justice Sergon and Madam Jedida. I think we could answer, we could hear out the questions, some of them, before we speak about the Kituo AJS model. So anyone with a question?
I have a question.
Thank you, Dana.
For Jedida, that was a very nice presentation. On also for Honorable Justice Segon. That was wonderful. You've mentioned human rights and the models that we have. There is one informal form that I can think of, and that is the use of the kangaroo courts, which is usually used in the villages to tackle issues of defilement. I know you've mentioned that AJS does not support the use of using AJS in dealing with sexual offenses. So my question is it, do you think it's important to have or to include in the policy the interventions that we can use to eradicate maybe the kangaroo courts? And if we want them to remain, because you see they're using AJS. So if we want them to remain, is there a need to have intervention so that we can be able to tell the people in the villages, yes, you can use alternative methods of dealing with disputes, but for these matters, use the courts so that we can have justice for families and for victims. And also on the same issue, maybe Honorable Justice Segon can talk about this, the use of AJS in criminal matters, especially when people are left to their own devices. You find that they use alternative dispute resolutions in tackling criminal matters. Now, leave alone sexual offenses, just other, like for example, murder. So I would love to hear your opinions on that. Thank you.
Diana, for that question. I don't know if the Justice or Madam Jedida would like to address the two questions, or are you ready to address them?
Let me go first and then we'll have the judge.
Okay. Thank you.
Thank you very much, Diana, for those two questions. As you rightfully put, Judge will focus on the criminal matters and AJS. One of the things I would like to mention is that remember, AJS has no divide that this is criminal, this is civil, this is constitutional. That is not a demarcation of AJS. However, let me focus on the kangaroo courts. My appreciation of kangaroo courts, actually, everything AJS was for a long time considered as kangaroo courts. So I think when you mention that name, the thing that comes to my mind immediately is the decisions made around by especially the chiefs and the wazes around the elders around the chief, and also the council of elders, the traditional council of elders, who determine everything from murder to defilement. I think if you listen to the human rights framework that I mentioned, I talked about the duty to protect, the duty to respect, and the duty to transform. Under the duty to protect, that is where the responsibility comes in to help all the AJS practitioners. And none of them will we call kangaroo, even if they're doing the wrong thing. I think it's to help them appreciate where the violation is and where the violation of the rule of law is to help them understand under the duty to protect, we must protect the human rights of every user of AJS. And therefore, how you manage defilement will inevitably violate the rights of the child. Because in many AJS communities, it is not the rights of the child which are important. That is not what is looked at. You look at the issues around the parents and the shame around the community. So if you approach it from a duty to protect, we have a responsibility to bring it to the attention that you cannot use AJS to determine issues of defilement, because inevitably the remedy that you provide violates the rights of the child. And you help them by helping them appreciate the Bill of Rights, help them appreciate what the written law is saying in terms of the Sexual Offences Act, and also help them appreciate that the AJS policy, because of the power imbalance and the power dynamics, we cannot deal with issues of sexual violence around AJS. I think it's very important for us to, and that is why when we think about awareness creation and training of the AJS practitioners is very, very important. So they understand what they can continue doing and what they must do differently by transforming how they administer justice and the nature of cases that they are able to determine. That way, one will be able to respect the duty to respect the AJS. Two will be able to promote the duty to protect the vulnerable and marginalized. And also, we'll be promoting the duty to transform, to help this AJS transform. So it tells me we have a lot of work to do as a civil society and also as the committee to have that attitude, the mind shift that there are certain cases that we must manage differently. And that is why the option of having a court annex AJS also becomes very important, because that matter is a matter that must be referred to court for determination, so that things around defilement or rape are properly managed in court, and the AJS can handle other matters, but not related to the crime of rape or defilement. So I think this is just a good question to help us appreciate the amount of work we need to do. The only thing I would say, let us stop calling them kangaroo courts, because indeed they are courts, but it's because of our history of violating our various AJS practices, which is a part of our colonial legacy that we must shift, so that our language is enabling, our attitude even to the wrongdoers is enabling, because we want transformation. We don't want to create enemies, but we want transformation in the administration of justice. Justice Sargon, thank you.
Thank you very much, Diana, for your question. Specifically, whether we can apply AJS in criminal cases. Perhaps, maybe as a background, before the promulgation of the Constitution 2010, the law under the Adjudicators Act had provided for the application of alternative justice system in civil cases only. There was no legislation which talked about the application of these systems in criminal cases, except of course when you look at section 176 and 204 of the Criminal Procedure Code, you realize that there was an indirect way of inviting the utilization of alternative justice system in resolving criminal cases. However, when the Constitution 2010 was promulgated, it did away with the classification of saying, okay, you can apply the traditional dispute resolution mechanisms in either civil or criminal. It left it open. And so the answer is you can apply alternative justice systems in resolving criminal cases. And even in the model courts that I alluded earlier, the alternative justice system is applied in resolving criminal cases. However, there was a recommendation that they should apply to petty offenses. And that one has worked so well. However, you are aware of some of the cases like the Abdu versus Republic, where the court recognized the application of traditional dispute resolution mechanisms in resolving some murder cases. And I also, in my own way, applied, although indirectly, in criminal, particularly in murder cases where a plea agreement has already been registered, so that you reduce the murder charge to manslaughter. Then alternative justice system kicks in when you have already convicted the suspect for manslaughter. Then what is remaining is to establish the appropriate sentence. And that's when now you invite reports from the relevant authorities in view of the fact that there are communities who, when they have lost somebody, either through murder or other ways in which someone has been accused, they say, okay, can we look at our traditions requires that before we admit this person to society, there should be some cleansing, should be some compensation. And of course, you realize also under the Criminal Procedure Code, question of compensation is recognized. So you basically trying to align our traditions to that. And that's why when you talk about applying the human rights-based approach, that is when now you say, okay, before you apply these customs, can you first go back? Does this one fall? Does this one, apply? Does it respect human rights? And the moment you use that one as a baseline, that is when you can apply AJS without serious breach of the law. So basically, that is the way the committee also, or the task force approached it. Thank you.
Thank you, Justice Sergon and Madam Jedida for addressing Diana's concerns or questions.
Perhaps maybe before I wanted to just give a slight comment on what Jedida had talked about, where you were talking about kangaroo courts, and I like the way she approached it. What I can only add is that when it comes to the application of AJS, like now in defilement cases, the most important thing we need to do is to sensitize and train the actors in this area. You train the panel, the elders, so that they can easily know, they can distinguish what matters they can take up and what matters they can refer now to the formal justice system. Thank you.
Thank you very much, Justice Ergon. Dr. Mbogo, your hand is up.
Yeah, okay, thank you, Martha. So my question is kind of related to the issue of resource mobilization for the committee for implementation of the policy, and also linked to what the Access to Justice cluster under the Open Government Platform is doing. So what the cluster group has been trying to do, and the cluster group consists of ourselves, Kituo cha Sheria, consists of the judiciary. We have Katiba Institute, Zalendo Trust, we have Haki Yetu, We also have the Coast Interfaith Council of Clerics, and we are now reaching out to academia to join. That's the Strathmore Law School and the University of Nairobi School of Law, who have expressed interest to be part of the cluster group. So the cluster group has been working on a memorandum in line with the commitments, mainly for purposes of pushing Parliament to increase financing for the judiciary, and more so for implementation of the AJS policy. So we've been able to review the current the budget estimates for this year, including the program allocations. But one of the challenges that we are experiencing, so that we can really put together a good memorandum to Parliament, is just the specifics as to what, for instance, does the committee need, to be able to execute the mandate that you have shared. This meaning in terms of financial or budgetary allocation. So my question is it possible for the Access to Justice Cluster Group to be able to get this kind of information, more specifically from, I've noted that you have a strategic plan. So based on the strategic plan or work plan that the committee is working on, what figures are we talking about, so that can inform this memorandum that would then be a tool for advocacy for more funding from the state to be allocated to the committee. I think that is it from my end. Thank you.
Thank you, Dr. Mbogo. Members of the committee, I'm not sure who would be able to address those concerns.
Yes, Judge, what is it?
Karibu. Madam Jedida.
Jedida, are you able to do that?
Okay.
I know there is a committee for resource mobilization, but
yes,
we can chip in, yes.
Yes, that's true. That's true. Thank you, Judge, and thank you, Dr. Annette. Yes, it is true. As Judge has said, we have a committee for resource mobilization that is part of the monitoring, evaluation, and documentation team, led by the chair, Justice Ngugi, and Dr. Steve Ouma is the chair of the committee. I think this question is very timely, and I'm not sure what time frame you have, because I have two answers. One, the presentation that Honorable Priska Nyota will be sharing has some of the things that we have done and we are planning to do. So maybe this may be a good time to have that intervention, or we wait for later. But two, and more importantly, within her presentation is we are hoping to have partners and donor round table, I think on the 13th of September, Priska, to really help share in detail what we are planning to do. And maybe I think also we should be able to share figures then. Right now we don't have any figures, but we should be able to. So depending on the time frame of when you need feedback for the estimates, if it can wait to then, that will be fine. But also, if you look at the policy, it has very clear actions to be done. So depending on what is the priority of the platform in terms of the issues you want to capture, the issues you can pick. The issue may only be the budget estimates that may be an issue. So we will share this feedback to the chair, but I think it will be good for you to help us appreciate the time frame we are working with. So that if it is before then we can prioritize and share the same. Because I think it's important to note that even during the task force, until now, the task force and now the committee hardly had any support from the judiciary because of the kind of constraints that were there. And it is our hope and prayer that this time, and especially in the implementation, we do not continue on the same mode, because it leaves a lot of weight and burden on the committee, but also a lot of weight on civil society and other development partners who channel the resources through the civil society to support the activity. I don't know whether Annette have answered your question.
Yeah, I think the timeline is a bit tight because we actually intended to submit the memorandum next week. So, but if we could get even rough estimates. There's someone who's okay. If we could, sorry. Okay, so I was saying that the timelines are a bit tight because we intended to submit the memorandum next week. But if we could get rough estimates, they can really help to beef up what we already have. But we can share as well what the draft that we have, and then maybe the committee can advise on what figures they would want us to indicate in the memorandum, because it's actually still also we have representation in the judiciary within the cluster group, so we just wanted specific information that relates to the committee itself. Yeah.
That's well, Dr. Annette, we can do that. We can do that. I think once you share with us, I'll just link up with the leadership, and then we'll ensure that we get the estimates as far to the best of our ability by next week.
Okay, thank you very much.
So I think we'll coordinate with you after this, right?
Okay.
Yeah, thank you.
All right. Okay, thanks.
Thank you, Dr. Mboko. Thank you, Madam Jadita. Addressing some of the concerns that Dr. Mboko has. It's also good to know that the fiscal will also give us more information on what exactly the steering committee intends to do. We are looking forward to that session. We'll have a plenary session right after the fiscal presentation, whereby we can ask follow-up questions based on the answers given by the committee members, and also new questions that we might have later on. So I'd like to proceed with the program. I will be speaking about the Kituo AJS model, and we'll have brief presentations from Salim Miruri from Pamoja Trust on how they're using AJS in their projects and activities within the institution. And I think also the representative, Madam Lillian from FIDA, might also give us some insights on how they're using AJS in Kisumu County, because we actually share a donor, GIZ, who is also funding some of the AJS activities in Kisumu with FIDA. Thank you very much. So as Dr. Mboko had said previously, Kituo's journey with AJS started shortly after the 2007-2008 post-election violence. Kituo stakeholders had a meeting with the former Honorable Chief Justice, Dr. Willy Mutunga, about how the victims and survivors of post-election violence could gain recourse following the sad things that happened to them during that period. So the conversation continued, and in 2016, Kituo cha Sheria, in partnership with the Public International Law and Policy Group, Amy's former employer, had a partnership in order to implement AJS in Western Kenya and in Uasin Gishu County. So there were two groups that were formed in those areas. These groups consisted of victims and perpetrators of post-election violence who felt the need to reconcile the communities in their areas, because those are some of the areas that had the negative effects of the post-election violence. Property was lost, lives were lost, and following the failure of the ICC cases, there was a need for forgiveness and reconciliation and hopefully justice for some of these people. So we trained, Kituo cha Sheria trained these community members in the form of adjudicators and commissioners on the law and on dispute resolution mechanisms other than the court procedures. So these two names were given not based on their exact meaning or their literal meaning, but based on the work that the adjudicators and commissioners are doing. So I will briefly explain what adjudicators are and who commissioners are. So commissioners were the victims and perpetrators of post-election violence who wanted to participate in the program. So they had a network, they had the IDP network, and from those networks in the areas, they form the category of commissioners. So what commissioners do is that they collect statements within the community. At that point, they were collecting statements of post-election violence. The cases that we were dealing with were of civil nature. They might have had a criminal aspect, but they were not, they did not involve physical harm. So these are cases such as probably someone took my cows or someone decided to take over my house during the post-election violence, the confusion thereafter. We did not want to engage in any cases of physical violence, such as rape, such as murder. We had people who were assaulted, physically assaulted using pangas and whatnot. So we did not want to enter into that, especially because the policy had not yet been developed. So we were not sure what cases would be within the parameter of the policy, which was still being developed. Next, we had adjudicators who were members of the host communities that accommodated the IDPs post the 2007-2008 post-election violence. There are also people who were found to be of good moral standing within the community. There were opinion shapers, such as elders, such as youth representatives, such as the women who are considered to be of good moral standing within the community. So these are the people who are considered to be to fit into the criteria for an adjudicator. One thing about the adjudicators is that they were not allowed to be victims or perpetrators of post-election violence, because the role they would play would be that of mediation. So once the commissioners come up with the cases and talk to the victims and the perpetrators or alleged victims or perpetrators, the commissioners would review the cases and see if they fit within the purview of the AJS model that we were trying to implement or that we were piloting. After that, they would proceed to share the cases with the adjudicators, who would then set a date for a mediation hearing. So during the mediation hearing, the parties to the case have two options. You could either have a public hearing or you could have a private one. And the hearing had to be voluntary. Both parties, both the victim and the perpetrator, would have to voluntarily participate in the mediation hearing. So once that has been set up, the adjudicators would act as the referees during this session. They would sit down, they would read out the statements as they had been collected. They would confirm that that is the information that was shared by the alleged perpetrator and the victim. And from that point, they would allow both parties to start speaking. In case any party has a witness
they would also be allowed to give their version of the story. After that, the parties would be allowed to have a session aside with some of the adjudicators and also the commissioners who brought their case before the AJS group, and they would discuss remedies. It did not necessarily have to be a full compensation of whatever you lost or whatever harm was done to you, but it would have to be something close to or something that was agreed by both parties. The remedy had to be something that is agreeable, because without that, both parties would not necessarily be satisfied with the outcome of the mediation process. So these cases take unlimited period of time. It could be an hour, it could be 1 day. You could have cases that take several days, like in the Western region, we would have to go and hear some of those cases several times, not just 1 day. But in areas like Trans Nzoia County, we would manage to have a short sitting, probably by short I mean a full day sitting, whereby we would talk about these issues. And by the end of the day, also having been prepared by the commissioners previously, the parties would come to an agreement. And we had cases whereby someone probably stole a sheep and they decided to return 2 sheep plus the children of the sheep. Pardon me, I've forgotten what the child of a sheep is called. Yes, lamb. Thank you, Janet. Yes, the lamb. They would also return a lamb if the sheep stayed in someone's compound for probably 2 years and had reproduced. There's a case in Eldoret that was very interesting. It was actually about sheep, and the person who had taken the sheep away from the neighbor actually returned the sheep plus the children, the lambs of the sheep, which was very good. And it was a sign that the perpetrators were actually, they had a guilty conscience and wanted to reconcile with the neighbors, because before that, they were living in harmony. They were actually very good friends. And some of these cases are actually documented. Kituo did the documentary with support from PLPG, whereby some of these cases were documented. I have shared a link in the chat of the shorter version of the documentary, but there's a longer version that in case any of you would want to have a look at, you can contact me separately and I will be able to share that with you. But yes, the Kituo AJS model is based on, it aims at forgiveness and reconciliation, as well as justice. But considering the fact that the project was piloted on the basis of post-election violence, our main aim was to foster cohesion within the communities so that we avoid the cycle of re-victimization. We wanted to ensure that communities are able, despite the ethnic background, communities are able to live together in peace and harmony, as well as to observe and to respect each other's human rights. So we thought through this model, we will be able to ensure that that objective is achieved. Kituo later on joined or started implementing the AJS in Trans Nzoia County. We had 2 areas of focus, that is the Endebess region, which is prone to violence during elections, and we had the Trans Nzoia region. We had the Cherangani region, a place called Suwerwa Bonde, deep into the village, Mashinani, in that area. And we had the same model of AJS implemented in the area. And interestingly, this last area of Trans Nzoia is whereby we had the most success. In Eldoret, we managed to implement more than 10 cases, and we had a rate of 7 successful AJS cases settled through the Kituo AJS model. In Western Kenya, based on the magnitude of the cases that were there, and also based on the period of time that we had to implement this project, we only managed to have 4 successful cases. But by the time PLPG was exiting the country, there were more cases that needed to be had. Unfortunately, by that time, FIDA had decided to take over that area, considering that they had an office in Kisumu, and they were also implementing AJS. I'm not sure how far that project is going with the Western chapter, but maybe Lillian will tell us something small about that. But as for Eldoret, we decided to proceed with the project with them. We're still working with them. We resumed last year, whereby we were not able to do the AJS project, but we did a project on gender-based violence due to COVID-19. But this year we have started working with them again on AJS. We have done training on the law. We have done training on alternative dispute resolution. We have taught both groups on how to handle hearing cases. We had professional mediators who were present and participated in the training sessions. And as Dr. Mbogo had said earlier, we have been implementing this project for 4 years. So in those 4 years, we have had 3 training sessions on the law, on mediation, on issues that are faced in society. We have had training on criminal procedure, the civil procedure in courts vis-a-vis AJS models. And we have made sure that we have built the capacity of the people that we work with in the communities. We were hoping that the policy would give us some guidance on what exactly to call the AJS practitioners, but maybe that exactly is the name, AJS practitioners. So we have since dropped the names or the titles of adjudicators and commissioners, and considering Kituo is mainly an organization that prides on its work with paralegals, we have now called them paralegals because that is the work that paralegals do. They assist the community in areas whereby they're probably not able to access courts or lawyers or the justice system. So that is what we have been doing in previously Western Kenya, in Uasin Gishu and in Trans Nzoia counties. Maybe I could just give a brief on the gender segregation of our members. In Eldoret, we have a team of 14 women and 16 men that we are working with. In Kitale, we have a team of 12 men and 18 women that we have worked with this year, that is. There's a training we held earlier in August, whereby Madam Jedida and Mr. Timothy from the NASA AJS participated in. They gave the opening remarks and they took our participants through the AJS policy. And considering the fact that our participants are mainly from the village, they were actually very cordial and managed to conduct the training in Kiswahili, which is very good, because not all of the AJS practitioners that we work with are literate. So that was actually very encouraging for them, and they were very appreciative and excited about the way the presentations were made. They were very succinct and they were very informative to the groups there. So generally in the whole team that we work with in Eldoret is a number of 45 people. We used to be 46, but unfortunately one of our members passed on last year. In Kitale, we had a big team of 60, but we kept narrowing down. Right now we have 45 active members that we work with in that area. And they are very excited about the work that we do. They're very excited about collaboration with the steering committee. And they're hoping
to be able to continue this AJS work and to be considered as valid and legal AJS practitioners. Yeah. With that, I think we will allow questions in the plenary so that I allow some of the other participants from the other organizations to give a brief on what they're doing in the AJS sector. Maybe before, as Janet from Kituo is meant to give a brief on what Kituo aims or has planned to do this year with regard to AJS. So I will allow her to do that before we go on break for 15 minutes. Karibu, Janet.
Thank you, Martha. Once again, my name is Janet Cavulovo. I work alongside Martha in implementing the AJS project. As you can already tell from the background which Martha has given, AJS activities focus on peace building. And just to have an idea of the kind of work that we do, I will give a brief of a project this year, which is called the AJS Project for Peace and Civil Education. Our objectives include to create awareness and build capacity of the community members and stakeholders on AJS within the purview of the AJS policy so as to ensure access to justice. So from the onset, this year's project was geared towards streamlining our AJS activities within the AJS policy principles and has also heavily borrowed from the opportunities and recommendations highlighted in the policy. Secondly, is to advocate for the use and coordination of AJS mechanisms among local authorities and government institutions. So as you can tell from what Martha was saying, we work at the grassroots level. So here we really focus on engaging with local chiefs who regularly solve cases in their offices on a daily basis. And then thirdly is to promote intercultural diversity for peaceful engagement in conflict situations, especially with the 2022 elections around the corner. So that was focusing on the 2022 elections. And then fourthly, to integrate mental health and psychosocial support into peace building efforts. So because remember that peace building and mental health and psychosocial support is crucial for to avoid cycles of violence. Some of the activities that we have done to ensure implementation of these objectives, and some of them which we are still yet to do, is that so far we have mapped out new areas so that we can expand AJS activities. And here we have engaged with chiefs of several sub-counties in our project areas. And then we have also done training and sensitization of adjudicators and commissioners, which now Martha has said we now will call them AJS practitioners and paralegals. So we have trained them on the AJS policy, and this was conducted in collaboration with the committee through my senior Jedida. We're also planning AJS hearings, also to develop and disseminate blogs. Blogs are video blogs, basically just videos to show people how to use AJS mechanisms to solve disputes, as well as to conduct radio talk shows. And this ties in with the first objective on awareness creation. We'll also develop popular versions of the AJS policy in English and Swahili, and we will do this in collaboration with the committee. We're also planning to develop a case digest of the successful cases thus far. And this one we will launch in our upcoming AJS Symposium, which is part of our activities. And we'll do this later in October. And then we also have inter-community dialogues on election violence prevention, as well as mental health and psychosocial support. And this is really geared towards mitigating the effects of possible election violence. Lastly, we have the AJS Symposium, which I was talking about. And this will just to be sharing experiences and opportunities. And I'm definitely looking forward to engaging with you with you all once again. So that's all that I have for now. Thank you so much for your time.
Thank you, Janet, for giving us that brief on the activities planned for this year between Kituo and our teams in Eldoret and I was happy to hear that there are several committees within the implementation committee that deal with some of the activities that we aim to do this year. For example, the jurisprudence and drafting committee, which I think would be very crucial to partner with, considering the fact that we want to print simpler versions of the AJS policy. So that is an area that we would like to get assistance from the committee in. And also the subcommittee that is dealing with documentation. I failed to inform the participants that we actually document our decisions. I had mentioned that we take statements from both parties who are engaged in the hearings in alternative justice system hearings. And we usually document the statements, and we also document the decision and have the participants sign that those are actually the sentiments that wanted to be represented in the agreement. So because of this documentation process, we are now able to develop the AJS digest, which will have all the successful cases that we have managed to tackle for the 4 years that we have been implementing AJS. So that is also another area that we would like to get the partnership and assistance from the steering committee. We would like to take a short break of around 10 minutes, then come back and have the presentation from Honorable Priska. And after that, we will have the plenary session. So we hope to see all of you in the second session. Thank you very much. We should be back at around 11:15.
Okay.
Thank you.
Thank you.
Martha.
Yes.
Please play the video that you have shared.
Pardon?
Please play the video you have shared.
Yes. I've requested our technical person to play the video.
We want to complement the justice system set up by the government. Those are the legal structures, the magistrates, because we are aware that the judicial system is overwhelmed by cases, and we know of cases that have been pending for the last 10, 15, or even 20 years. We want to step in.
Tumeweza kufanya kesi nyingi ambayo imeleta reconciliation kwa watu wengi, na tumeona matunda ambayo yamezaa katika location yetu, location Nigeria, sub location Kabongo, lakini mengi yamefanywa na tunaona watu wameishi kwa kupendana, watu wameishi kwa ushirikiano mwema. Ile mambo ya post election violence tunaona sasa katika Uasin Gishu County imepungua.
Hii kikao imenisaidia kwa maana nilikuwa nitakwenda kuchukua pesa yangu nyingi, lakini imenisaidia sana.
Gari ilichomwa, biashara ilichomwa, iliporwa. Sasa mwenyewe nikasema nirudi jua kali, nione kama wanaweza kubali tu niingie kidogo. Angalau nifanye kazi ndogo ndogo tu nifanye nipate riziki yangu tu ya kila siku. Mimi kufika jua kali ndio ilikuwa kifo changu hiyo wakati. Nilifika nikapigwa kelele, wakapiga nduru, wakakuja na mawe, wakaniambia wewe Kikuyu unafanya nini hapa? Hatutaki wa Kikuyu Kisumu. Fanya ukienda kabisa kama utaki kukufa. Kidogo tu wakarusha mawe. Nikigeuka watu washaja. Mimi ile nika panic. Nikaketi penye nilikuwa. Mimi kuketi hapo mtu mmoja ndio akakuja. Akapata niko surrounded wananitukana hapa, wanasema nini? Huku niko Wajaluo nafanya nini huku sistahili kuishi. Iliniuma sana. Nikachukuliwa nikaondolewa. Nikaambiwa sasa ukienda, jipe time urudi kama 2 or 3 months hivi. Nikakutana na watu wa kituo cha sheria. Kukutana na hao watu nikasikia naumwa sana na nina uchungu moyoni, nataka kusaidika, nitasaidikaje? Tukawa na mafunzo mazuri sana ya kutufunza jinsi ya kusameheana, jinsi ya kufuatilia mambo, jinsi wanaweza kutusaidia vile tunaweza kupata wale watu ili tuweze kupata mali yetu. Mimi mwenyewe nikafuatilia hao mafunzo, nikasikia ile kidonda kiko moyoni kimeanza kupona. Baada ya kupona ile kidonda ya moyoni nikasema sasa hao watu nitawafuata mimi mwenyewe, hata sitataka usaidizi na watu. Vile nimepata mafunzo, nitaenda na hao mafunzo mpaka huko jua kali niongee na hao wajamaa. Nichongea na hao wajamaa nione kama tutaelewana.
Popote pale wale wote tumekuwa katika mafundisho haya, tumepata elimu ya kuwa nikirudi mahali nitakapokuwa, pawe na mzozo wowote ule, kuna jinsi nitakavyoingia katika ule mzozo na jinsi ya kuelewa ule mzozo ni nini kinachosababisha ule mzozo, na nitakuwa na nafasi nzuri pia ya kupatanisha wale wenye ule mzozo na kuweza wale wenyewe kubali kusameheana.
We want to complement the justice system set up by the government. Those are the legal structures, the magistrates, because we are aware that the judicial system is overwhelmed by cases, and we know of cases that have been pending for the last 10, 15, or even 20 years. We want to step in.
Tumeweza kufanya kesi nyingi ambayo imeleta reconciliation kwa watu wengi, na tumeona matunda ambayo yamezaa katika location yetu, location Nigeria, sub location Kabongo, lakini mengi yamefanywa na tunaona watu wameishi kwa kupendana, watu wameishi kwa ushirikiano mwema. Ile mambo ya post election violence tumeona sasa katika Uasin Gishu County imepungua.
Hii kikao imenisaidia kwa maana nilikuwa nitakwenda kuchukua pesa yangu nyingi, lakini imenisaidia sana. Sasa nitaenda pata shamba yangu.
Kwa makosa rafiki yangu anaitwa Paulo Wafula. Tumekaa, tumeelewana na tumesameheana. Na mimi nikapenda majirani yangu wenzangu ile nile sawa, kama hata nao nikosea watu na itaikuwa ikikuti tukakuje wasameheana na majirani.
Nimefungua roho yangu kabisa, nimeweza kusamea rafiki yangu, ndugu yangu Julius. Tuishi maisha kama ile ya zamani, ile alete tu maziwa kama zamani, tuendelee na ukasoma wetu kama zamani.
Sasa nashukuru Mungu nimerejea pale pale na niko mahali pangu pa kazi. Nashukuru sana. Gari ilichomwa, biashara ilichomwa, iliporwa. Sasa mwenyewe nikasema acha nirudi jua kali, nione kama wanaweza kubali tu niingie kidogo. Angalau nifanye kazi ndogo ndogo tu nipate riziki yangu tu ya kila siku. Mimi kufika jua kali ndio ilikuwa kifo changu hiyo wakati. Nilifika nikapigwa kelele, wakapiga nduru, wakakuja na mawe, wakaniambia wewe Kikuyu unafanya nini hapa? Hatutaki wa Kikuyu Kisumu. Fanya ukienda kabisa kama utaki kukufa. Kidogo tu wakarusha mawe. Nikigeuka watu washaja. Mimi ile nikapanic. Nikaketi penye nilikuwa. Mimi kuketi hapo mtu mmoja ndio akakuja. Akapata niko surrounded wananitukana hapa wanasema nini? Huku niko Wajaluo nafanya nini huku sistahili kuishi. Iliniuma sana. Nikachukuliwa nikaondolewa. Nikaambiwa sasa ukienda jipe time urudi kama 2 ama kama 2 or 3 months hivi. Nikakutana na watu wa kituo cha sheria. Kukutana na hao watu nikasikia naumwa sana na nina uchungu moyoni. Nataka kusaidika, nitasaidikaje? Tukawa na mafunzo mazuri sana ya kutufunza jinsi ya kusameheana, jinsi ya kufuatilia mambo, jinsi wanaweza kutusaidia vya kuweza kupata wale watu ili tuweze kupata mali yetu. Mimi mwenyewe nikafuatilia hao mafunzo, nikasikia ile kidonda kiko moyoni kimeanza kupona. Baada ya kupona ile kidonda ya moyoni nikasema sasa hao watu nitawafuata mimi mwenyewe, hata sitataka usaidizi na watu. Vile nimepata mafunzo, nitaenda na hao mafunzo mpaka huko jua kali niongee na hao wajamaa. Nikiongea na hao wajamaa nione kama tutaelewana.
Popote pale wale wote tumekuwa katika mafundisho haya tumepata elimu ya kuwa nikirudi mahali nitakapokuwa wawe na mzozo wowote ule, kuna jinsi nitakavyoingia katika ule mzozo na jinsi ya kupekua kuelewa ule mzozo ni nini kinachosababisha ule mzozo, na nitakuwa na nafasi nzuri pia ya kupatanisha wale wenye ule mzozo na kuweza wale wenyewe kukubali kusameheana.
We want to complement the justice system set up by the government. Those are the legal structure, the magistrates, because we are aware that the judicial system is overwhelmed by cases, and we know of cases that have been pending for the last 10, 15, or even 20 years. We want to step in.
Tumeweza kufanya kesi nyingi ambayo imeleta reconciliation kwa watu wengi, na tumeona matunda ambayo yamezaa katika location yetu, location Nigeria, sub location Kabongo, lakini mengi yamefanywa na tunaona watu wameishi kwa kupendana, watu wameishi kwa ushirikiano mwema. Ile mambo ya post election violence tumeona sasa katika Uasin Gishu County imepungua.
Hii kikao imenisaidia kwa maana nilikuwa nitakwenda tuma pesa yangu nyingi, lakini imenisaidia sana. Sasa nitaenda pata shamba yangu.
Kwa makosa rafiki yangu anaitwa Paulo Ofula. Tumekaa, tumeelewana na tumesamiana. Na mimi nikapenda majirani yangu wenzangu nile sawa kama hata nao likosea watu na itaikuwa ikikuti ikakuje wasameheana majirani.
Nimefungua roho yangu kabisa, nimeweza kumsamea rafiki yangu, ndugu yangu Julius. Tuishi maisha kama ile ya zamani, ile alete tu maziwa kama zamani, tuendelee na ukastoma yetu kama zamani.
Sasa nashukuru Mungu nimerejea pale pale na niko mahali pangu pa kazi. Nashukuru sana.
Hello, are we back?
Yes, we are. So, karibuni sana. On the AJS models for feeder and Pamoja Trust. I don't know if Sally, you're back yet, so that you can just give us a brief presentation on what Pamoja Trust have done under AJS. Sorry, Martha, did you call on Pamoja Trust? I didn't hear you clearly.
Karibu Sally.
Okay, thank you. Thank you, Martha, and thank you for the previous speakers for the conversation that you have engaged us on. So I work with Pamoja Trust. Pamoja Trust, for those who do not know, is a civil society organization, and we work in about 7 counties in Kenya. We are dedicated to promoting access to land, shelter, and basic services for the urban poor. So one of our programs revolves around access to justice. And over the years, we have been champions of out-of-court settlement. Before the launch of the alternative justice policy, we had involved ourselves in documentation of cases, more so in northern areas, in how the people use various ways to resolve their disputes, more so disputes regarding land. And so we were able to document this and work with the task force to influence the outcome of the policy. So after the launch of the policy, we have worked with the various partners in implementing the policy itself. And one way that we have worked to implement the policy is working with government institutions who have the constitutional mandate to work on areas regarding land, like the National Land Commission. So we've worked with the National Land Commission and other institutions specifically, and I would measure, we've worked with many areas, but I'll measure in Turkana. In Turkana, we've worked with the NLC and other stakeholders. So the NLC spearheaded the formation of a committee that had an interest in resolving the land disputes in Turkana area. So we know Turkana is largely community land. And so we have worked with the committee to see how AJS can be used to resolve community land disputes, and also to see how to link the different actors in the land sector, how they can come together in the agenda of dispute resolution. And so the committee itself is, of course, spearheaded by the National Land Commission, as I've said, and the county-based NLC. It also has representation from the Law Society of Kenya. It also has representation from the Ministry of Land, religious leaders, civil society representative, and I think others that I might not remember now, but it is a multi-stakeholder committee that was formed with an aim of resolving dispute and trying to link the various actors in the land sector, so even with the community, to resolve disputes in Turkana. And so we focus in Turkana because we know of the land aspects in Turkana, like the oil, the natural resources that they have. We also have the aspects like infrastructural development, like the road projects, that of course are being built on community land. And so the processes have to be harmonious so that these processes do not deprive the community of their lands. We have recently partnered with the National Steering Committee on Implementation of AJS to see how we can work with the committee itself to jumpstart their work and even to just help them tackle some of the challenges that are already coming. I don't think the challenges, but some of the gaps or some of the challenges that might come up with the implementation of the AJS. We have mentioned some, and I think Dr. Annette had mentioned the resource mobilization aspect, that most of this AJS practitioners and teams have been bringing up how to handle the resource mobilization and implementation of AJS. There's also the criminal matters issue that have been asked a lot. So we are currently working with the steering committee in trying to provide a direction and a path to these questions and the challenges that the committee is facing right now or might face in the implementation of AJS. I think there are issues to do with the documentation and even registration of cases that the committee will be handling. And so we've also worked with other organizations, like we are planning to partner with the Legal Resource Foundation and also again with the steering committee to see how the committee in Turkana will be able to effectively document cases and even register them. When it comes to the model that Pamoja Trust is really looking at, Pamoja Trust works at the grassroots level and we work with the urban poor. And so our work is majorly geared towards working with the grassroots community members. And we have also implemented AJS by working with the communities, first by training them on the scope of AJS, on the scope of what alternative AJS entails. And we've been able to do this, benefiting from the fact that we were able to work with the task force in developing of the policy itself, and even the fact that the policy has been unveiled. And so we have used this to train the community members to understand what the scope of AJS is and even the background of it. We've also worked with the community to be able to understand how they can document the cases and how they can refer these cases. Because most of the cases might reach a point where they need expert opinions or expert advice. And so we have worked with them on how they can be able to identify the cases that they can resolve at the very grassroots level. And so this would kind of direct Pamoja Trust to the typology that Commissioner Jededa had presented earlier, which is the autonomous level, which is purely independent. We leave the community to resolve their disputes as they are without interference from like civil society organization, with administration like the chiefs. So we have done this by identifying key people in the community, like the community elders. We also have human rights, they're called HRDs, human rights defenders, who work at the community level to be able to then form what we have called AJS teams to resolve disputes then at the grassroots level and to try and promote the autonomous typology that was mentioned before. So we are still trying to, of course, continue to train so that people are able to understand really what AJS is. I don't think the trainings are one-offs. We continue to train the communities to understand what AJS is, and also working with the duty bearers and these times the institutions that are mandated to work in the areas land and even provision of basic services. And so that we can link both the communities and the duty bearers, and as we implement AJS, so that they can see what each of their roles is in implementing AJS. I have mentioned how we've worked with the communities and how we're working with the duty bearers. And I think we currently we're also trying to see how we can synergize with civil society organization, and that's why we thank Kituo cha Sheria very much for organizing this meeting. I think it's important for us to see what other civil society and NGOs are doing when it comes to implementation of AJS, so that we see how we can support the communities and even link the communities with the duty bearers. And even and I think in implementation of AJS, it comes to a point where the formal system, which is the judiciary, plays a part, and also how we can link the implementation of the AJS and even the formal system, which is the judiciary. So I don't want to go into detail, but in short, that's what we have done, working with the communities, the duty bearers, in implementation of AJS. Thank you, Martha.
Thank you very much, Ali. It's interesting to find out that some of the challenges that we have faced in the implementation are also the challenges that you're facing. For example, reference of AJS cases. We had cases in Kisumu whereby we needed some assistance from the survey office, and accessing them had been a challenge, but I'm sure Dr. Phoebe, who is the chair of the Kisumu team, maybe later on might be able to tell us what the progress of that case was, and especially in the land disputes whereby we need a lot of reference from the registrar's offices and such. Yeah, we are still working on how to assist our communities in the grassroots levels in tackling such cases. So thank you very much, Sally. And it's also good to know that you are also supporting these such conversations with the AJS stakeholders, so that we see how organizations can partner within themselves and also with government institutions as well as international partners in order to ensure that AJS can be adopted to solve disputes. Thank you very much, Sally. I would like to invite Kuto from our Mombasa office to also share what the activities, that they're planning for this year. The AJS project in Mombasa for Kituo started this year. So we are very happy that we are able to broaden our wings and to assist more communities in different areas in the country. Karibu, Ruben.
Thank you, Martha. So yeah, as Martha has said, we have been tasked with implementing the AJS system or AJS policy in Mombasa this year, and we actually began the program early in June, and we began with the idea of promoting and creating awareness of the AJS policy within Mombasa County. We realized that just as other areas of the country, AJS policies existed, and what was needed was a streamlining of these systems, and as well as creating a model whereby, as it has been highlighted earlier on, creating or promoting human rights in regard to when we exercise these AJS systems. So we work with district peace committee members, village elders, paralegals, and religious leaders. And this is due to the fact that these four stakeholders are mainly engaged in dispute resolution within Mombasa County. Aside from the judiciary, we found that these four were actually trusted by the community when it comes to dispute resolution, or when issues arise within the communities in Mombasa County. The district peace committee members, we work with the specific committees within the 6 sub-counties, that is Mvita, Likoni, Changamwe, Nyali, Mvita, Likoni, Changamwe, Nyali, and Kisauni. With the district peace committee members, we have said that we have had stakeholder engagement, and that was through the mapping of the AJS stakeholders, which was the first activity that we did in Mombasa, so as to get to have an idea of the exact stakeholders that we can work with in terms of promoting and creating awareness of the AJS policy. And we also got the opportunity to interact with the other community members and the issues that are affecting the community within the 6 sub-counties. We have also been able to conduct capacity building of the AJS stakeholders that we intend to work with. And they are mostly from the 4 stakeholders that I have mentioned, that is the DPCs, the village elders, the paralegals, and the religious leaders. And unfortunately, due to the COVID regulations, we were planning on doing public barazas, and these were geared towards creating and promoting awareness now on the local level, that is with the community itself, and getting to hear the issues and actually referring the cases that are highlighted in these meetings to the district peace committee members or the village elders, the paralegals, or the religious leaders. Or we can also take up the matter ourselves as Kituo or involve our volunteer advocates. But unfortunately, we haven't been able to conduct these barazas because the number targeted is above the regulations, the stipulated regulations. Our other planned activities are promotion of the AJS policy or AJS through media campaign, that is through radio talk shows and wall murals, or popularly known as graffiti. Now, the graffiti or murals were to be drawn in strategic places in Mombasa County, to promote the message of peace building, and reconciliation. This would ensure that the community or anyone who visits Mombasa is able to know or is made aware that such system is being practiced in Mombasa, and that it is a key facet of dispute resolution in Mombasa County. I believe that's our planned schedule of activities and how far we've gone with the policy advocacy. Thank you.
Thank you very much, Ruben. We are glad to know that the Mombasa team has come up with very innovative ideas on how to promote AJS. I understand also that there are some activities that involve using sport as a way of advocating for the use of AJS, which is very good, very commendable. Thank you very much, Ruben. Lastly, I would like to invite Lillian from FIDA. I'm not sure if she has joined us again, to just give us a brief on what FIDA does before Honorable Priska takes over. Lillian Jumba.
Hello, I'm here.
Karibu.
Yeah, my name is Lillian Jumba from FIDA, Kenya. Maybe if you can help and unmute me from your end. I can't unmute, I have to hold my space bar down as I talk.
Sam Felix, kindly assist us with that.
Yeah, kindly if I can be unmuted from your end. My gadget is misbehaving. Oops, okay. As we wait, I can continue. Can you hear me?
Yes, we can.
Okay. For FIDA, I want to talk about how we've been engaging with the AJS, with the elders, And for FIDA, what we do with the AJS is just to ensure that women that we serve under the Access to Justice program are able to access justice in the communities at the community level. We have quite a number of elders that we engage with. And when I talk about elders, I'm talking about the Council of Elders in different communities. And I'm also talking about chiefs because we put them in the IJS. And they help us a lot in handling cases at community level, especially land cases, and also cases, family matters that may not really get redressed from court. And when I talk about that, I want to give an example of a case whereby first wives, sometimes you find them being neglected in the community after spouses get second and third wives, and use the cultural aspect, especially like for the Luo Council of Elders. We use the elders to talk to these men to consider supporting their wives, because traditionally you find that in the African tradition, you find that women were taught to stay home as men work. So you find people working, living together for many, many years. And then when the relationship gets sour, you find the women suffering because of the cultural aspects, like the example I've just given. So in such cases, elders have really come in handy in helping us handle these cases and helping us get the women to access justice. What we have done in the past and are still doing is training. We do radio talk shows to just sensitize the community on the importance of elders. Some of the Council of Elders that we have engaged closely in the past and currently Kakamega elders, we have Kisi, we have Othaya, we have elders from the coast, given that FIDA covers the whole country when it comes to handling access to justice issues for indigent women. And in our 3 regional offices, we serve women from all over the country. I want to give an example of a woman traveling all the way from deep West Pokot to come and get justice, to come and access, get legal advice in the Kisumu office. So for such women, working with the informal justice system has helped us to have them get justice, maybe handling them at our office level, and engaging elders from the areas where they come from to help them get justice, and to also link them with other like-minded partners like FIDA who would help these women to be able to access justice. Doing the community radio talk shows, especially using the vernacular radio stations, helps us to sensitize the community on the importance of access to, importance of elders in access to justice. We've had cases of succession for women in the communities. We've had cases of maybe just matrimonial issues, boundary disputes, where we where clients come to us in the office and we refer them to the elders that we work with. To do this better, we have a network of elders all around in the places where our clients come from. We get numbers of chiefs and put them in a database whereby it's easy to access chiefs from the very, very many areas. Some we just get from our clients themselves. We ask them for chiefs numbers, they give us, and we call and write to these chiefs to help us and help these women. And we also get our clients come for legal aid. And in these legal aid clinics, we have legal aid clinics because in the many areas, we organize in partnership with some of our like-minded partners. We organize with CBOs to have legal aid clinics. And in these legal aid clinics, we invite elders and have, before we do listen to the participants one-on-one, we have a small talk on the importance of AJS, the importance of involving elders. And we are being cognizant of the fact that most of the cases that come by in the communities may sometimes never even get to reach to FIDA. Sometimes in most cases, they just are handled by elders in the communities. There was this question about what we are doing with elders in Kisumu. I think Martha mentioned. In Kisumu, mostly we have worked with the Nyakach elders. And why we are working closely with Nyakach elders is that they have a very a clear system of in their structure, whereby the Nyakach elders is made of elders from clans that are domiciled in that area. And to handle cases, our clients, what we do is, as we refer, we call the Secretary General and inform them about a case in a given area. And what they do is refer us to the elder in charge of that particular area. And this elder would then choose another elder from different area, just in Nyakach, and then maybe meet in the client's home to solve cases, or maybe meet at the chief's office to solve cases. And usually these cases are cases we know very well that if the participants, the feuding couple, or maybe the feuding people, if they sat and listened to these elders, then the cases would be solved. And again, we take advantage of the male gender being very receptive to instructions or views they get from the males. So we take advantage of the clan elders to be able to sit and sort some of these cases, avoiding litigation, and of course, in making sure that enabling our clients to get justice faster. Some of the challenges we get as we engage with the elders is sometimes documentation. We are trying to train our elders on case documentation. They are very good at, of course, talking and getting to solve the cases, but a big challenge when it comes to documentation. Another challenge that we get, especially when working with the chiefs, is that we know chiefs are usually chosen from the locality where they may have grown up. And in some areas, you will find them related to most of their people, the people from the area they cover. And when you approach them for cases, we've had cases whereby chiefs would say, like, they may not be able to handle these cases because they're related to the people we are referring them to, asking them to handle cases it becomes a big challenge. And now we have to write sometimes to the ACCs to help handle these cases. Those are some of the challenges that we get. Other challenges that we get is that we are not able to get to all the elders in the Kenya being a very, FIDA having only 3 offices, having to cover the whole country. Sometimes we have that challenge of not getting the right people to help us in some places. And being able to, sometimes struggling a lot when we have cases that we feel would be handled by elders. Another question I would like to handle is the question on our partnership with GIZ. GIZ has actually funded us to be able to give some token to the elders that help us handle cases in the communities. And for those elders who are able to do the documentation well, because it is vital in this case, we've been able to support them and refer cases to them, and them also referring cases to us that they think, to FIDA Kenya office, I mean, that will be able to be handled in cases that need some form of litigation, cases to do with in succession matters. We've been able to handle, of course, they sit, talk, help the families to agree on how to maybe distribute property amongst themselves. And then FIDA coming in to work with the courts, of course, and get those agreements being adopted by courts. Basically, that's what I want to say on how FIDA works with the elders. And I want to say, as I finish, I want to say, as we work with elders at FIDA, mostly we look at accessing justice for our clients at the most basic level. Thank you so much.
Asante sana Lilian Jumba from FIDA Kenya. As you can see, there are very many different AJS models that different organizations use. I think they should show that the committee that work is being done, and we are also depending on you to guide us on how to do this. So I would like to finally invite Honorable Priska to take us through what the committee has for us going on forward. Thank you very much, Honorable Priska.
Okay. Good morning. It's still morning.
Yes, good morning.
All right. I'll make a very short presentation, and it is basically an update of the steps that the implementation committee has taken since the launch of the AJS policy last year. And there are 4 steps that have already been taken, and they include induction, sensitization, mapping, and also planned activities. And I'll give a brief details on each of those steps so that we can get to familiarize ourselves with what has been done. Now, with regards to induction, the new members of the committee have been updated, and they have familiarized themselves with the committee's terms of reference. There has also been identification and establishment of the program implementation unit at the Judiciary Training Institute. There was also conceptualization and formation of working subcommittees so that they can reflect the different TOR areas and work on them. And those subcommittees are 3. The first one is Public Education, Training, Awareness, and Sensitization Committee, which is headed by Commissioner Emeritus Jadida. There is Jurisprudence and Drafting Committee, which is headed by Madam Emily Chwea, who is based at the Office of the AG. And lastly, there's the Resolve Mobilization, Monitoring and Documentation Subcommittee, which is headed by Dr. Steve Okoth. At the induction level, identification and development of 2021-2022 operational plans with specified deliverables and timelines has been done by those committees. Now, on sensitization, we have developed draft standard training documents for awareness creation and sensitization. We've also developed pre-training tools to gauge the participants' understanding of AJS. We've developed a monitoring and evaluation plan, and we've shared sample monitoring and case documentation tools. Further, we have sensitized on the AJS policy and implementation opportunities through partnerships with CSOs. For example, in Kajiado, with FAO, Turkana with Pamoja Trust, Uasin Gishu, Trans Nzoia with Kituo, and Nairobi City County with the Legal Resources Foundation. And this partnership is meant to sensitize and accelerate implementation of the AJS policy. And also the opportunities have come through court CUCs, like in Nakuru, Kibera, and Nairobi City Court CUCs. Then again, we've been able to distribute copies of AJS framework, and the distribution continues as the rollout progresses. Now, the third step that has been taken is about mapping, where mapping of various stakeholders to engage as partners to enhance AJS sustainability. And this has been done to the judges and magistrates, the administration of justice stakeholders, CSOs and FBOs, community and cultural elders, and court users committees. Mapping of CSOs and development partners for resource mobilization, technical support, and joint projects has been ongoing, and it will continue as long as it's needed. And then lastly, the fourth step is on the planned activities. And these are now going to give us the areas where we can cooperate and we can partner in. And one of those areas is reprinting and translating into Braille, sign language, Swahili, and other local languages of the AJS policy. We will also document AJS case digests and jurisprudential analysis. And then also there are those annual reports to the Chief Justice for inclusion in the state of the judiciary and the administration of the Justice Report, popularly known as SOJA. Then we are also looking at CSO and Development Partners Roundtable, which is slated for Wednesday, 15th of September 2021. Madam Jedida had alluded to this. Then we have another activity which involves engagement with various court user committees, starting with Nkumbu Law Courts, Nairobi, and then Shanzu. Then we have an activity which involves CSO trainings with UNDP and Amkeni wa Kenya supported, which are UNDP and Amkeni wa Kenya supported projects. And we have targeted Coast Region on 13th to 16th of September, the Northern Region from 20th to 23rd September 2021, and Nairobi and Western regions on between 27th and 30th September. Thank you very much for listening to me. It was as long as that. Asanteni sana.
Thank you very much, Honorable Priska. We are glad to see that the committee has a lot of activities that we can partner in, and we are hoping to get invites for most of these activities. I've seen that you also had the same planned activity of translating the AJS policy into Braille and other languages such as Kiswahili, which is something also Kituo aims to do this year. So that is one area that we have seen we will partner with the committee on. Also, the idea of documenting cases for a very long time. We have not had a reference area or reference place whereby we can see what organizations are doing on this in AJS. So we would also love to partner with you in the in documenting cases through an AJS digest, which is also an activity that we intend to do this year. You have mentioned others, which I think we can be able to have further discussions on, not only Kituo, but also the other organizations represented here in this meeting. With that, and also considering time, I would like to invite the participants who joined us in the process of the presentations or have just joined us right now. And after we are done with the introductions, we will go to the plenary session. So I'd like to invite the new participants to just introduce themselves. If I could mention Mr. Sam Orlando from Pamoja Trust, kindly say hi to the participants. It seems he's unable to do that at the moment.
I've just unmuted. I was struggling with finding it. Many thanks for the invitation, and I'm happy to see Honorable Sergon, who has been a champion for the alternative justice system. And thank you, Kituo cha Sheria, for hosting this webinar. It's my hope that as civil society organizations working in this space, we shall join hands and have also a framework that allows us work in synergy. Thank you so much, Martha.
Karibu. Next, I'd like Tracy to greet the participants.
Hello, everyone. Good morning. I hope you're all well. Thank you so much for that insightful session. I've got to learn so much, and we look forward to working with the other institutions in order to implement the alternative justice systems policy. Thank you.
Thank you, Tracy. That's Tracy from our legal department at Kituo cha Sheria. I'd like to invite Mr. Michael Obiambo from our Korogocho Community Justice Center to say something small.
Hello, everyone. I'm Obiambo Michael, coordinator and a paralegal. I'm also Commissioner of Justice and Peace, working in Korogocho Community Justice Center, a partner of Kituo cha Sheria. Having listened carefully to what has been happening in the company of my colleagues who are with me here, actually, I realized that most of the things we are already practicing in our community. Because in most cases, you find that we are handling cases which are very sensitive, and we do them practically. Some of them, like we are doing alternative justice at the same time. In fact, in most cases like housing, tenants, landlords, housing, you know very well that in Ngomongo, Korogocho, we've had a lot of issues with tenant and landlords. Gender-based violence is also cutting across. So we have a lot to do, and I pray that we get more training and more activities coming in on the ground. Thank you very much.
Thank you, Michael. Next on, I would like to invite Madam Valerie Angawa to greet the participants before Janet takes over and handles the plenary session. In the meantime, kindly think of the questions that you'd like to ask the committee members, because it's not very common to have such sessions. Karibu, Madam Valerie.
Good afternoon, everybody. I hope you can hear me now.
Yes, we can.
Yes. Yes. So good afternoon, everyone. It's a pleasure to be here. It's a pleasure to see everybody participating and giving fruitful contributions to the conversation that we're having about AJS. As the team in Kituo has explained, we started this process some time back, and it is such an honor to see it get to where it is now. It's always a pleasure, of course, to hear from Commissioner Jedida. We've had several communications and conversations and meetings with her. And yes, so it's really nice to see you. It's an honor to be graced with Honorable Judges Sergon and Honorable Priska. Thank you so much once more for joining us. So my part is just to say hello. I will give my closing remarks towards the end. Yes, so really good job, Martha and Janet and the whole Kituo team.
Thank you very much, Valerie. Lastly, I would like to invite Mr. John Mariri, who is the head of the legal department at Kituo cha Sheria, to just say hi before we go to the plenary. Thank you.
Hi, everyone. I'm John Mariri. I just want to thank you for inviting me for this meeting. I just wish to say that I found the discussions as very insightful, and I know they are going to be very useful to the communities down there. I would also want to echo what Sam Orlando has said, that we are looking forward to seeing, the organizations that are working around this space, working together, partnering for the benefit of the communities. So thank you very much as we go on to formulate the policy. Thank you.
Asante sana, Mr. Mariri. We have several other members of staff from Kituo cha Sheria, but we'll allow them to say something small after the plenary session or during the plenary. So I'd like to hand over to Janet. Thank you.
Thank you, Martha. I am glad that more structured AJS activities can now gain traction with the policy and the way the committee has planned its activities. So I'm really excited for this partnership, even in the coming years. There's a concept I've recently come across, and it's called the critical juncture concept. I'm not sure if it can apply here, but to me it applies. And it refers to situations of uncertainty in which decisions of important actors are casually decisive for the selection of one path of institutional development over other possible paths. So hopefully this traction that I'm seeing puts AJS activities on paths that continues to rise. I don't know if that makes sense. But I just wanted to say that before I allow participants to raise their questions. So if we have anyone that would like to ask the presenters questions, this is your chance. You can raise your hand. Yes, Martha.
Thank you very much, Janet. My question goes out to Madam Jedida, and this is a question that has been shared by Joseph Maura, who is our AJS coordinator in Uasin Gishu. He informed me that you were recently on KTN, speaking about AJS, and you managed to talk about the accreditation of AJS practitioners. And I think you also mentioned that as you were giving your presentation on the AJS policy. So his main concern was, will there be a specific criteria? Will it be guided by academic qualifications? And considering the fact that AJS mechanisms are a grassroots, they are grassroots type of mechanism, will it leave out the people who are currently working on AJS and people who have been champions of AJS, for example, the village elders, the Nyumba Kumi members, and other communities, community paralegals, and such like people? Thank you.
Go ahead, Senior Jedida.
Okay, thank you very much for that question from Joseph Mwaura. And I'll invite my colleagues too to assist in this answer. First of all, I don't know when I was in KTN talking about accreditation of AJS practitioners, maybe another accreditation like paralegal, but not AJS. I think if you listen to me carefully, and if you recall, one of the strategic objectives of the committee is to figure out, strengthen, and streamline the selection, the election, or the appointment of AJS practitioners. The AJS policy in no way locks in or locks out anyone. It provides a very robust approach to AJS because it recognizes all those issues that you're saying that usually when we talk about accreditation, usually when we talk about criteria, we think about books and papers and academia. AJS is not based on books and papers and academia. It's based on indigenous practices. It is based on the sovereign will of the people. The concept that Janet has spoken about, I'm going to look for it and appreciate it. It's exactly that. AJS does not lock out anybody. It provides a space for everyone. And that is why I also spoke about the human rights framework that ensures that there is protection, there is respect, and there is transformation. So the committee has not developed any criteria. Indeed, it will not develop a criteria that is based on academia. It may only develop regulations or guidelines or values or principles that ensure issues of like integrity, issues of accountability, issues of the rule of law, issues of human rights protection and promotion are respected. Because you do know very well that very many AJS practitioners don't have the schooling privilege that you and I have. And that does not mean that they make worse decisions than I do. In most respects, they make better decisions than I would, because they are based on acquired learning of the community and wisdom of time that many of us may not have. So I'm not sure which clip he's talking about, Joseph Mwaura. And so there is no criteria at all. And that is why when we were thinking about the various typologies or the various AJS models, we were shy to have a regulated AJS model. Because once you start going through that route, that is where the limitations based on books or education become more important than other aspects that are very AJS specific. So worry not, Joseph Mwaura, there is no such criteria or accreditation. There is no national accreditation of AJS. In fact, each typology or each model will have to develop its own appreciation of the way it elects or the way it selects or the way it appoints the AJS practitioners or adjudicators or commissioners, whichever name that you will give them. So, and this is a process too, that once that process starts in terms of developing guidelines, it will be a process where we are going to be involved in one way or the other. So there may be general guidelines, but there will also be very specific things that are peculiar. The things for me that will be very general will be issues about inclusion. Are women part of the selection AJS panel? Are the youth part of the AJS panel? Are persons with disability part of that panel? What is the place of the elders in that panel? Especially when you think about third-party models, which will be more based on a lot of people who are within the schooling realm or academia. So I would not worry about that, and do not fear that this is what is going to happen, because once we go this way, then we'll kill the entire foundation of the AJS process and the AJS philosophy. Justice Sargon and Honorable Priska, please say something.
Okay, just to add on what Commissioner Jadida said, it's true, we do not want to formalize or regulate the practices which have been going on since time immemorial. What the committee intends to do, or what it has done, is to encourage them to come out openly. You know, they have been doing their thing down there without any formal recognition, though they do 80 to 90%, they deal with 80 to 90% of the disputes at the grassroots level. So the moment we recognize them, that yes, they assist in expanding access to justice, they assist in, you know, reducing the backlog in courts, in resolving disputes, they promote harmony and all that. The moment those practitioners and actors realize they have been recognized, they are being appreciated, they will come out openly. And in the process now, even the people concerned, people at the grassroots level, will be able to say, yes, we have this panel of elders. They are recognized by the formal justice system. They are recognized by the government. Yes, let us go there. Then now what we are saying is, let us now align them to the constitutional principles. Let them understand that there are human rights, you know, baseline, so that whatever they do, they fall in place without breaching the law. And the other aspect which maybe will come out later is engagement with the county, the county governors, for them to facilitate and for them to, like now we've had a fully established committee, AJS committee in Turkana County. There is one also which is about to be launched in Kajiado County. So those initiatives are encouraged. And in the process now, all of us, civil society, steering committee, will be able to relate with these systems, do the sensitization, do the training, and we will be able now to move forward and see a very established AJS system. Thank you.
Honorable Priska, something?
Commissioner, I don't have something to add. Judge has said everything.
Okay, thank you. I think just before we go to the next question, it's important to note Justice Sargon usually gives us, tells us that if the elders, the council of elders summon him, he will go. And yet when you put the level of education between them and him, it is far apart. But he respects them and he submits their authority. So it is not about education. It is about the trust and the work that they are doing in the community.
Thank you. I hope that is clear now. Do we have any other question? If you can just allow me to take you back a little bit. I'm not sure if you mentioned it. When you were talking about the committees that you have formed in Turkana, are they something that the committee will be supporting, or are they independent institutions? Just a bit of detail on that. Thank you.
Janet, I think you're referencing what Justice Sergon has mentioned. When for Turkana, it is under Pamoja Trust. So we just are taking note that it's one of the committees that is has been established with the county governance framework being involved to resolve disputes. So that's what, there is no committee or any AJS that the committee has formed. What we are doing is looking out for where they are, and some we are being invited to engage into. So for Turkana, it is with the Pamoja Trust, and that is what Sally was sharing. And we've had an opportunity since inception being part of that process, because they have involved the task force and the committee over time. For Kajiado, it is spearheaded by FAO, the Food and Agriculture Organization. And again, we were again brought into the picture for Kajiado, and the county government of Kajiado is fully involved and part of the infrastructure of the AJS framework. So no, the committee does not is not establishing anything, because that is not our mandate. Our mandate is not to establish any AJS. Our mandate is to work with the existing AJS in all their forms, shades and shape, and where there are no AJS, if there is a place like that, which I doubt, is to help them think through that process, and then they make a determination whether that is the way to go. But I doubt whether there is any place where there is no AJS. The only thing is that we don't know about it, or they are conducting their work in a very hidden way. But ours is to share and raise awareness that no more hiding, no more degrading of AJS. AJS is part of our dispute resolution mechanism, so long as you're enhancing access to justice and doing what it takes to resolve disputes, create peace and harmony, we are okay. And these are the guiding parameters to strengthen and improve on your service delivery. Thank you, Janet.
Thank you so much, and I have understood, and I agree with you on the point of non-interference with how communities do their AJS. I will invite Michael Odhiambo. I know you had raised your hand. You can go ahead.
Hello, everyone. I just wanted to ask a simple question. My question is that since I said we've already been practicing this unknowingly, maybe we knowing or we are not in the picture, but then what happens when an AJS has been done and one party decides to breach what you've agreed on? Is there any other way you can redress, or you can come out with some kind of redress about this? Or can you repeat it? You do another AJS again. What actions can you take in case of one breaches?
Judge, want to go on that?
I did not hear the question. So is inaudible.
He's asking, Michael is asking, what avenues or what can someone do if AJS has made a determination and the decision is respected? Do you go back to the same AJS, or what can you do to
Okay.
bring process?
It's basically asking for if you are dissatisfied with the a decision from AJS mechanism. Okay, what I know is that various communities have different structures in this system. Like now, if I give you a good example of the Kipsigis, they have several levels in which one can approach. You can approach, and if you are unable to agree with the decision of the panel of elders, you can easily use the same system, appeal for your case to be reheard by another set of elders or by an expanded panel of elders. Then from there, even if you are dissatisfied again, you can still call for more, for other elders from within the same community, but you can get it from other regions, but within panel of elders. So it is possible for you to appeal through the same system. And of course, what we're saying is that courts should be so reluctant in intervening. But that does not mean you cannot approach the court. You can still approach the court, and that is where we sort of what we want to do is to create a link between now the formal justice system, which is the formal courts, and the AJS system, which is generally informal. So that you are not bad, but there is that sense that we need to recognize them, let them have their own system of dealing with matters and finalize once and for all. Thank you.
Yes, thank you, Judge. Just to add on to that, I think one of the typologies is on court annex model. That helps again in strengthening the whole issue of having your decision documented and filed in court, and also it's a good order that you can use for compliance. Doesn't mean that the court order is better than the order that is given. It is just an affirmation. I think it's more so because of where we are coming from. Really, what we need to be able to do is to sensitize our communities on the importance of the decisions made by AJS. And as Judge says, nothing stops you from approaching the court to register that decision so that there can be compliance. And especially on very serious matters that the court needs, that you need the assistance of the court to ensure full compliance. Again, the human rights framework on duty to respect, duty to protect, duty to transform comes into play. Lastly, as paralegals, as community workers, as HRDs, we need to make a lot of entry with the court user committees, so that where you have this kind of situation, especially if you have an AJS forum which does not have the levels of appeal, it is a flat, or there's no way of review, then because it depends. The complaint can be from the complainant, the victim, or it can be from the person who is responding to the issue. But you need to have a place where you can be able to have your matter reviewed. So the court user committees is a platform where you can discuss some of the challenges that the AJS practitioners are facing and develop homegrown specific solutions that will ensure that at the end of the day, justice is done and people are able to access justice and the decisions are respected, those that are made by the AJS, even before the court intervenes. And so there's no one answer, but I think it's to look at how do you develop an AJS that has a review process within it to help, and also are there certain decisions that must be referred to the court, that will need to be referred to the court, so that there is a reference point and there's an additional authority level that helps you in the compliance. For example, in Turkana, one of our advice was given that we are dealing with land issues and we know the weightiness of land issues. How do you, even if you're a third party, nothing stops you from referencing and having those decisions filed. If at the minimum, you just want them filed in court so that and affirmed in court so that later or during the implementation of that decision, there's no one running to court and giving a different alternate answer. Thank you very much, Michael.
Thank you. I think that was very exhaustive. If there is no other question, I wish to invite Valerie Angawa to close the meeting for us. Deliver the closing remarks. If any participant has any further questions, you can address it to the emails that were sent via the invite, and we'll be able to forward them to the committee members. So thank you so much, participants. If Valerie is on this call, please go ahead.
Janet, may I say something just before?
Yes, please.
Thank you very much for inviting us as the National Steering Committee on the implementation of AJS. This is a very important consultation for us because we begin to appreciate some of the models that are out there, the work that the civil society is doing, and also the opportunity that is there between civil society and the committee towards the implementation of AJS. For us, I think it's important to note that we are an open door committee, and you have an opportunity to engage with either through your representative in civil society or directly with the chair of the committee or the vice chairpersons. We have two, that is Madam Emily Chwea, representing the Office of the Attorney General, and Dr. Steve Akoth, to raise any issue and any concern or any opportunity that you may want us to work with you as AJS is implemented. I think our vision and our commitment is to ensure that AJS, in terms of implementation, is accelerated, it is mainstream, and it's implemented according to the parameters that the AJS policy has proposed, and also developed further, because the AJS policy is just the first blueprint and just the beginning or the foundation to much more jurisprudence, to much more documentation that will ensure that AJS is accepted and implemented. Finally, I want to say that let us assist the community to shift the understanding that AJS is not an opposite or as a minor component of the judiciary, but really is part of the implementation strategy to ensure that judicial authority and also the resolution of dispute is fully implemented, so that as a country, we are able to live in harmony, we are able to develop, and we are able to cohere in all aspects of our life. So alternative justice system is a critical and important component in the administration of justice. So it's important that we all work together to ensure that this is appreciated, this is respected, and this is used to transform our lives from all aspects of our, in all aspects of our lives. So thank you very much, and God bless you all.
Thank you. We are excited as well to be able to partner with the committee at this critical juncture. So thank you for the engagement. And now I wish to invite Valerie. Welcome, Valerie.
Thank you so much, Janet. Thank you to all the participants, and thank you as well to the facilitators who have made it today. Thank you for the fruitful engagement as well. At this moment, I would wish to just give some closing remarks on behalf of Kituo. We appreciate the efforts that you have put in to support the work that Kituo is doing and in the bid to ensure that access to justice is actually realized. Through the use of AJS and the efforts that we have made as Kituo, we do not take it for granted that the judiciary has taken a keen interest and is the major proponent for the use of AJS. I would wish to appreciate on behalf of the judiciary the presence of Honorable Justice Sergon and Justice Priska as well for taking you're very, I know you're very busy at this moment, but that you took time. We've been here for hours since 9 to 12. We do not take it for granted, and Kituo truly appreciates your support. And I would also wish to appreciate Commissioner Jedida and the task force members, the committee members on AJS. Thank you so much once again for your commitment to access to justice and in making it very easy for Kituo to partner with you as well. For the participants and stakeholders and like-minded organizations such as FIDA, Pamoja Trust, LRF, we do not take it for granted that you have supported us over the years, and we look forward to engaging with you more. GIZ for enabling this function to actually happen. We wish to give them a hearty thanks. And the Board of Kituo cha Sheria, who is represented by our Executive Director, Dr. Annette. Thank you so much for supporting us through this. Would also wish to thank the paralegals, that is Michael, I will not mention all of them, Larry, let me see if I can mention them. Sometimes it's good to mention people's names so that they know you're thinking about them. Yes. Well, I don't see most of them here, but I think Mauro had joined at some point. Thank you so much for your support. The rest of the Kituo cha Sheria staff who have taken their time off their busy schedules to support the work that the AJS team is doing, including the Mombasa team as well. Thank you so much, Ruben, for joining in. And lastly, I would also wish to thank Martha and Janet, most especially and most sincerely, for coming in and handling this particular session and discussions very well. It has been quite interesting and it has borne fruit. Just a keynote for the rest of the participants. We look forward to engaging with you during the symposium, which is coming up, I think, in October or November. That is going to be an auspicious event, one of its kind, where we'll be able to showcase some of the work that the task force has been doing, the judiciary, our participants and our beneficiaries as well. So please be on the lookout for the email from Kituo to participate in this event. We'll also be engaging with you closely, the task force as well, on documenting. One of the things that I have taken home is that we cannot learn something if we do not document it. One of the problems that we have had so far is documenting some of the success stories that we have had in the AJS work that we have been doing. So I'm really happy that the AJS platform is there and that the AJS policy has been enacted and that it is taking shape. It might be slow, but it is taking shape, and that's what is most important. So yes, with that, I would wish to call this meeting to an end. Thank you once more. Martha, if you would wish to say a few things, maybe just administrative issues, this will be the opportunity for you to do it. But so far, we have tried to keep time, which is good. So thank you so much once more.
Thank you, Valerie. Mine is just a request to the participants. If we could take a photo, our able technical person, something, will take a photo for us. And I would kindly request you all to put your videos on so that he is able to capture everyone's presence for this meeting. Kindly put your cameras on.
I'm just waiting for Brenda, Phoebe, John Mwariri, and Martha. Put your hands on.
I've joined with two, so mine one is on. Felix, please tell us when to stop smiling.
I'm having the last one now. Yes, awesome.
Thank you. Thank you very much, everyone. You are allowed to leave the meeting to your own pleasure.
Thank you very much, Martha.
Thank you. Thank you, everybody. Martha and Janet, maybe we could have a meeting with you as soon as everybody leaves. Kindly. Martha and Janet, I hope you heard me.
Yes, we did.
That is an invitation for everybody else to leave the meeting.
Martha, I'm making you the admin, then I'm leaving.
Okay, thank you.
I'm the host. Yeah.
Sam Felix. Sam Felix.
Yes, yes.
Before you do that, are you able to remove, is there a feature for removing the rest of the people?
Yes, yes, yes. Let me remove.
So that you just leave the three of us.
Yeah. Let me read them. Yeah, let me remove them.
Okay.
Now you are the three of you.
Oh goodness, I think I forgot to ask Ruben as well to join. Oh my goodness.
Maybe we can give him a call.
Yeah.
I call him to rejoin.
Yes, because I think this also touches on his activity.
Martha, you're the